in Hogan concerning the Parkburn area adjacent to, and I'm going to say Pizer moorings, and I'm hoping that's correct. There's different schools of thought on that, but please correct me if that's wrong, but Pizer moorings. Thank you to everyone for your attendance and the effort you've gone to in producing evidence and legal submissions. And I believe we're going to be presented a joint witness statement, which shows that some people have been working very hard in the last couple of days. So do appreciate all those efforts. Now, before we go any further, we'll just have a karakia from Commissioner Day Cleveland.
Whakataka te hau ki te uru, whakataka te hau ki te tonga, kia mā kina ki uta, kia mā taratara ki tai, he aki ana te atakura, he tio, he huka, he hauhu, ti hei mauriora. Thank you for that. All right, we'll just have a short introduction from the panel and staff. My name's Gary Ray. I'm an Independent Hearings Commissioner. I'm chairing this panel today. Just very briefly, I've been involved in several hearings in Central Otago District over the years, and certainly looking forward to this one. I'll just hand over to my fellow commissioners to introduce themselves. Morena koutou, I'm Ros Day Cleveland. I'm based in Otapoti, Dunedin. I've got a background in resource management planning, and I've been appointed to the panel as an independent commissioner.
Thank you.
Hi, I'm Ian Cooney. I'm a Central Otago District Councillor. I'm on the hearings panel, and I've also sat on the panel for the recent Plan Change 19.
Thank you for that. At this stage, we'll just do do attendance call now, and I see the proponents team is there, so maybe we'll just have an introduction of your team now, Mr.
Kevin, my name's Phil Page. I'm solicitor for Auckland Hogan this morning, and with me at front desk is Helen Hogan, who's from my chair, the Galloway for Gallup. We start from the Bill's end, just Bob Willis from Auckland Hogan, environmental advisor, Paddy Baxter, landscape architecture expert witness, Anderson Clare, Auckland Hogan's Central Otago regional manager.
Oh, yes.
And Nick Ross, who's the project manager for this project.
Okay.
Nick's not giving evidence today, but he was available to answer questions about the project if need be.
Yes.
Kerry Vivian, our planning consultant from Queenstown.
Thank you.
And online from our team, we should have Dave Smith, our traffic expert, and Reese Hill, who is our soils expert.
Right, thank you for that. Thank you. And just for the record, the panel has issued a minute just advising we have no questions for Dr. Peter Forrest or Simon Beale, Ecology and Geotech. And so that presumably is why they're not here. We have no questions for them. So, but thank you. We have got their statements of evidence and we'll duly consider those. Thank you for that. There are no submitters in attendance, are there? Are there some submitters here today? No. We've got an itinerary, and they're due to appear. Two of them are due to appear later this afternoon and also tomorrow. So, just the proponents team at this stage. So, thank you for that. Now, just in terms of the itinerary, obviously the proponents team goes first, and we have some submitters. The panel intends to do a site visit at lunchtime, and that really, the way I see it, is just a drive out to the periphery of the site, down through the access road, which I went on yesterday to have a look, and it looks like you can get access to sort of both quarries, or at least you can get to viewing points where you can observe from there. And there appears to be a sealed road that goes into the quarry itself, and I presume we can just drive along there without any impediment or trouble. Is that correct?
Well, being an active quarry site, Auckland Hogan has certain health and safety commitments needs to do. So if you want to go into the quarry itself, we need to arrange for and to have to be met and briefed in the company. Yeah, no, the way I see it, we'll just drive along what looks like a road that's unobstructed with gates or anything, and we won't enter onto the site itself, onto the quarry site. So we'll see how that goes, and if we feel we need to go back for any reason, we'll arrange that with you. But at this stage, it'll be just a sort of a reconnaissance trip. So. Yeah. Okay. Well, thank you for that. We'll do the initial visit at lunchtime and then see if we need to go back. But thank you. I think our main concerns are to do with the periphery of the site. So, so thank you for that. Now,
just for in terms of procedural matters, I was going to ask if there are any, but the panel has been issuing minutes in the course of this leading up to the hearing. We've indicated that we initially had some concerns about the relationship between PC19 and PC21, and that has been addressed through a memo from the council, and also in terms of legal submissions. But we are interested in that topic. I think in terms of the natural justice issues, we're not quite so concerned about that. I think that's been pretty well dealt with, but we invite you to go through that, Mr. Page, today, and we'll see if there's any further questions on that. The other matter is the NZTA Wakakotahi business. We'll hear more about that today. It looks like some work has been done on a joint witness statement. Just for the record, we've been asked to accept the filing of evidence tomorrow, towards the end of proceedings, and we didn't think that was appropriate. So it looks like that's been dealt with through a joint witness statement. So we'll hear more about that. Other than that, are there any other procedural issues to arise at this stage, other than what I've just discussed?
No, not covered.
No, okay. And I think everyone in the room today is well familiar with hearing procedures, so I won't go into that. But I just ask that cell phones are turned off, and in the event of emergencies, I believe we just go through those doors there. I'm imagining, and out onto the car park area. There are some public toilets just in the foyer there as well. And just also, I believe the session is being taped. Is that correct? Yes, so we're being taped. If anyone, recorded, we're being recorded so we can go back and look at the notes later. But if anyone has any difficulty with that, now's the time to let us know. No? Okay. All right, in that case, unless there's anything further, we'll hand over to Mr. Page to take us through the legal submissions.
Just able to check the two people online can hear and see us.
Oh, yes, so just check that the two people online, Mr. Hill and Mrs. Hill and Smith, are hearing us well.
Yep, loud and clear, thank you.
Yep, we're hearing you too. Good, thank you.
Yes, I can hear you. Can you hear me?
Yes, we can. Thank you. That's good to know. Thank you.
Thank you.
All right.
All right.
Thank you.
The batting order in terms of the evidence that you're going to hear, but this, unless you want something different, because you can direct me accordingly. Anna Sinclair will give the evidence first, followed by Bob Willis. Paddy Baxter will present a summary of his evidence, and what he will do is also to produce a plan for you of how the structured plan would operate in the event that we cannot get consent from the Otago Regional Council to create a connection to Lake Dunster. And so it's not a change to the proposal, but it answers the what if question in terms of that lake connection.
Thank you.
After Paddy, then our online witnesses, Dave Smith on traffic and Bruce Hill on soils, will join us. And then Kerry will give us a planning evidence in person.
Right.
He has filed some rebuttal evidence that he will speak to and be able to update you on where matters have landed in terms of Wakakotahi discussions.
Thank you. Yep.
And in terms of your program, we're going to hear from Fraser Colgrave.
Yes.
First thing tomorrow morning. Fraser's our economist who will be able to address you on the shortfall of current supply versus demand. And where the current population of the Cromwell urban area is in terms of the NPSUD.
Right.
And so, as you would have seen from my opening submissions and from Fraser's evidence, our submission will be that we're past 10,000 now. So we're tier 3, NPSUD is 5.
Right, thank you. And just in terms of the presentation, Mr. Smith is going before Mr. Vivian. So will Mr. Smith be talking about the Wakakotahi joint witness statement? Or
yes, he will be. So he has prepared a summary of the witness evidence from which he discusses that.
Okay.
I think we will be able to get that circulated before Mr. Smith gives us the evidence.
Yeah.
But I think what I can tell you at this stage is that we think we have reached agreement with Wakakotahi there was a joint witness statement doing the rounds, but there are about 3 different versions of it, and people have signed 3 different versions of it, and that has to be redone.
Yeah, that's fine. I guess if we can be told the gist of it, and then it can be presented in a more formal way at the end of it with all the signatures and so forth, that would be all right.
Yes.
Yeah.
Well, the gist of it is essentially that the provisions that Ms. White and Mr. Vivian put up are acceptable in terms of the trigger.
Right.
But there's some additional requirements in terms of forming connection to Pony
Court. Yeah.
the listed pies and moorings road connection to
Yes.
Pony Court.
Yeah.
There's a pony involved somewhere. Right.
Okay.
And also a connection available to the Lake Dunstan cycle track.
Right. Okay.
And with those things resolved, we understand that Okakota are heavy.
Right. Okay. No, that's good. I just thought I'd mention that because if Mr. Vivian's addressing at the end of proceedings, Mr. Smith might go into those areas as well at the start, but that's fine. We can deal with that.
Well, and so it was Mr. Smith's modelling, which gave rise to the roundabout upgrades and thresholds for that. So he'll be able to explain having arrived at that assumptions have made.
Very good. No, that's fine. That's all in order? Yep. We'll proceed on that basis. Thank you. Yeah. Okay.
So with a bit of luck, then the fact that Okakota have been able to produce evidence ought to be known again to the expert.
Yep.
Kind of makes sense from Otago's point of view because Otago are the regulator of the state highway. So
yeah,
we're in their hands one way or the other.
that's true. Yeah.
Now, my written legal submissions, I wasn't proposing to insult your intelligence by reading those to you. I can do if you'd rather I did. What I thought I would do is perhaps hit the highlights of that.
Yeah, no, that's fine.
And move through reasonably quickly, and we can perhaps develop some dialogue over matters which might be of particular interest.
Would you like us to ask questions as we go, or
Yeah,
you like that? Okay.
Yeah, I would much prefer that we did this in a sort of Socratic
Yeah,
style,
okay. Yeah.
lecture style.
That's fine. That's fine.
So I start at page 1.
Yeah.
From Fulton Hogan's point of view, the question that this plan change addresses is what you do with the quarry at the end of its economic life.
Yeah.
Fulton Hogan needs the certainty of what the forward direction is for the site and what to plan for it. Because, of course, the planning to create a master plan for residential development is substantial, particularly in relation to infrastructure design and supply. So from Fulton Hogan's point of view, this is really a long-term strategic planning exercise answering the question, well, what do we do when we finish digging up the rocks?
Yeah.
That's what this is about.
Okay.
And unusually for an urban development plan change, nobody has come out of the woodwork and said this is a terrible idea. And that's really odd. I've not been involved in an urban development plan change where that dynamic is at play. But then on the other hand, when you go out to the site, as you likely will have done already, will continue to do so, from a neighbour's point of view, it's not entirely surprising. It is evident that the code requires a warrant rather than next door residential development and a written warrant. And that's entirely understandable. So that's why in my paragraph 3, I've said that this is really a win-win proposal. Nobody loses in an adverse effect sense by the long-term strategic plan for the site being a residential development.
Right, and sorry to interrupt, just paragraph 2, before we move on, the 10,000 people for the Cromwell Basin, is that in the context of the NPSUD urban environment? So your submission is that the Cromwell Basin is the urban environment, not just the settlement itself? Yes,
well, that's something that Mr. Smith can speak to.
Right, okay.
More detail around how the Stats New Zealand data collection works.
Okay.
So there are 3 statistical areas that Stats New Zealand use as the Cromwell urban environment. And so the test of the NPSUD is it's predominantly urban. And so that's the population is predominantly urban as opposed to the land area being predominantly urban.
Okay.
So not all of the 10,000 live in Cromwell, but the statistical area that is treated as Cromwell is now, according to Stats New Zealand's modelling, 10,000 people.
All right. Well, the reason I asked this has come up in several other proceedings in Cromwell,
Yes.
other plan changes I've done in the past, and there was divergent opinion on that, but the NPSUD gives clear direction that that's the way for it to be interpreted.
Yes,
Yeah.
and the plan change 19, which is still on foot, there's various items of legal advice from council's lawyers to the panel in relation to that. And I think I'm aligned with the advice that Matt Todd had given the council.
That helps. Thank you for that.
Yeah.
Okay. Thank you.
I mean, and so just to sort of flesh that out further, even if the actual number as at today is less than 10,000, it is an urban environment that is intended to be more than 10,000 over the life of what's within the long-term range.
And is the word intended related to zoning or strategic plans? The word intended, does that have meaning in a formal way in terms of it's been zoned?
Well, the SUD doesn't explain what it means by intended.
Right.
But the well, because of the way the NPSUD worked, council can't simply draw a fence around an existing urban area and say that's it, no more, it's shut, it's closed. It has to make provision for forecast growth. And so I suppose what is meant by intended is what is predicted.
I see. Okay, thank you. And just to capture that, Mr. Todd provided legal advice to council in PC 19 to that effect.
Oh, Mr. Todd. It was Mr. McDonald.
Oh, from Matt Todd. Sorry.
Yeah.
McDonald. Okay.
And sometimes Mr. Todd is at Matt Todd.
Thank you.
So you'll find that advice on the CADC's website if you want to access it. I don't disagree with
that's fine for now. Thank you.
There's really nothing of controversy in the decision-making framework part of it. That is also set out in the section 42 report, and I don't disagree with anything that's said there. So coming to page 3, the existing environment.
Yep.
And the existing environment is really only of significance for the two contexts, and both of them relate to NPSs. One's the NPS highly productive land, and one's the NPS indigenous biodiversity. So the first thing to be clear about, and the point that I report does make clear, is that the quarry activity, and you'll see on page 4, the map scheduled area 35A.
Yeah.
So the quarrying is scheduled within the operative plan, and that SA 25A area is to be carried over. So there is nothing in plan change 21 that sets the uplift of that schedule. So the scheduled area will continue, and as will the activity rules that go along with it.
Is there any intention to replace that in time, do you think, or is it there to allow quarrying to continue for some time, for some length of time?
Well, I mean, that is the quarry is going to continue for some period of time, and that's Anna and Rob will be able to explain how that works from a company strategic point of view.
Yeah. So
the intention is to work from south to north.
Yeah.
So there will be a period of time. We've got residential development being undertaken at the south end of the property while quarrying and quarry processing is still happening further towards the north. So that's why the scheduled activity area isn't proposed to be uplifted from the plan, because we still need it.
Yeah, you still need it. Yeah. Okay. Thank you.
On page 5 of my submissions, you will see an image from the existing land use consent for quarry activities. Now, because you'll see that SA 25A doesn't go all the way to the state highway. What is known as the upper terrace wasn't part of the occupied scheduling. So since 2007, Fulton Hogan have had a resource consent to quarry the upper terrace, and that's shown cross-hatched on page 5. There is an existing area as part of that consent, which requires 20 metre setback from the state highway, and you would have seen a bund that's been planted in the site visit. And so that effectively will continue with under the structure plan that's proposed. The 2007 resource consent requires the land to be stores and pasture. So that's in the 2007 consent area, that long-term restoration, I suppose, is part of the existing environment, because that's what that consent requires. So in the event that you approve the plan change, what Fulton Hogan will then need to do is apply and vary the 2007 consent so that they don't have to restore it back to pasture. So that they can then pick up the what the zoning limits, which is to development for residential purposes.
Got a question on that. So from a legal point of view, is that necessary? The plan change, the rezoning doesn't remove a resource consent's legal effect? No.
No, so,
Okay.
so Fulton Hogan will continue to exercise the consent.
Yeah.
And because they're exercising the consent, they're bound by its conditions.
Yeah.
So there will be a period where there's a disjunct between what the plan provides for as long term, assuming you adopt plan change 21, and what the resource consent requires in terms of rehabilitation.
Right.
So what Fulton Hogan had to do was apply under section 127 to vary the existing land use consent, so that instead of rehabilitating it as pasture, it will be developed under what will be the then zone rules.
Yeah. And is that captured in the provisions in front of us, or is that
No,
it's not?
it's
Okay.
not.
Right,
We didn't
okay.
think it needed to be.
No. Okay.
It was just one of those things that are on a long list of things to be implemented subsequently.
All right. Thank you.
But when you ask yourself from a statutory assessment point of view, what is the existing environment? The exercise of the consent is
Oh,
part of that environment.
All right. If you guys have any questions, yeah.
It's one question for me. That area subject to that consent,
Yes.
that is not, am I correct that that's not the area subject to the HPL?
No,
No,
that's right.
right.
So if you're looking at page 5, my solutions where the image is.
Yep.
And you can see in blue, we've got the waterways coming down the side. And what is mapped by Manaki Whenua as LUC3 is effectively that eastern lobe to the right of the river.
Okay.
Right. Okay.
The
Thank you.
rest of it is not LUC3.
Thank you.
And so what we've had Dr. Hill do is do a more detailed mapping exercise with updated information about what's there, and he can explain that to you.
Okay. Thanks for
It
that.
could be the soil that might have been mapped in the 1970s isn't there anymore.
All right.
Okay. So from a national policy statement of Indigenous biodiversity point of view, let's forward to paragraph 22 here. On one view of how section 74 of the Act works, we are required to do an SNA assessment through this plan change. And so that's what Mr. Beale was asked to do.
Yeah.
And so he did identify a couple of examples of a cushion plant called Rheolia. But his evidence is that because it's common in the ecological district, it doesn't bring significant weights like SNA. And in any event, as Mr. Vivian's evidence explains, part of the existing environment is that we're allowed to dig it up and eat it. That brings me to page 8 of my submissions, where we leap into the relationship between PC19 and PC21. What you will see from Mr. Vivian's evidence and from the 42A report is that we've had a bob each way. What was sought through PC21 was two alternatives. Changes to the operative provisions and also changes to the provisions that might be anticipated should PC19 apply to the site.
Right.
So anybody who paid careful attention to the PC21 documentation would have seen both of those options there. However, your jurisdiction is limited to changes to the operative plan because it's a plan change, it's not a variation.
Yeah.
So you get to make, sorry, I don't know whether you've been delegated a recommendation role or an actual decision making role.
I believe it's a decision making role. Yeah.
It is the actual decision.
Yes, I believe so.
So your jurisdiction is to amend the operative plan insofar as within the scope of PC21. The tricky bit happens is if the PC19 panel's decision comes out first, then what is it you are amending? Are you amending the rural resource area, or are you amending the zoning of the site to include PC19 provisions? My view is that the simplest way of thinking about this is that you just get on and make the decision. If your decision comes first, and our team really has no idea where the PC19 panel's at in the decision-making process, we don't have any insight into that. If the unless and until the decision comes out on PC19, you just carry on like your plan's your plan. If the PC19 decision comes out, then those rules have legal effect from the date of the decision, regardless of whether they're appealed. My submission to you is that if you haven't released your decision on when the other one comes out, what you should do at that point is call for another set of provisions to be filed by preferably on a joint basis by Mr. Vivian and Ms. White, but if they don't agree, then they can file their own set about what the PC21 relief would look like in the context of the PC19 decision.
Yep.
So that's how we think that works.
Just on that point about the rules having immediate legal effect, are there any changes to objectives and policies that are also encapsulated in?
Yes.
There are, so that it would only be the rules that would have effect.
Because the low density residential zone and the medium density residential zones, those whole methods aren't part of the operating plan now.
No.
There's whole chapters that come in. But we're not seeking changes to those provisions as I recall together. Only the rules.
And in terms of that timing, when you say the decision comes out, there's also an appeal period, isn't there?
Yes.
So we would presumably wait until the end of the appeal period too. Which,
Oh, well, you could.
Yeah.
Because there's no burning hurry on you issuing your decision in the sense that it's 2 years, I think, from the date of notification. So it's not as if we've got 15 working days staring us down the barrel.
No, that's right.
And so, but I suppose if you wait for the appeal period to pass, the appeal will lodge, then what do you do?
Okay.
So I don't know that it actually takes you a while.
I think what we'll do is we'll ask for an update on PC19's decision-making process from the reporting planner.
Yes.
It probably won't be able to give us a date or anything, but it might give us some idea of the months or weeks involved.
Yeah.
And we'll just, as you suggested, make a tentative decision on what we've got in front of us, and then see where things lie in terms of timing at that point,
Yes.
and make decisions at that time. But that's useful to know.
And so if you end up going first, They're still writing faster than they're writing.
Yeah.
And your adoption plan change has been recommended. What Fulton Hogan would then do, and that, or Ms. White could do it, or both could do it, is lodge a copy of that decision with the PC19 panel.
Yeah.
And invite them to deal with that through PC19.
I see. Would that be a final decision or some sort of interim decision that we would give to the PC19 panel?
Well, it's simply a way of formally alerting the PC19 panel that the operative plan has been changed through your decision.
I see. Oh, I see. Yeah.
Because
all right.
Fulton Hogan has, in its decision on PC19, sought rezoning of the Parkburn land. Now, it's material to the PC19 panel to know what the operative plan zoning is in order to understand how to respond to that.
I see. Yeah. Okay. So the key point is to coordinate with the two different panels to make sure it comes out in a coordinated fashion.
Yeah.
Okay.
And because the council elected to notify both PC19 and PC21, it must have assumed that somewhere along the line, two processes would get tied together so that incoherent decisions would get made. So what we're trying to do is say, what does that look like in practical terms?
Interesting to know whether they actually turned their mind to that issue, but that's certainly how it would appear to look.
Well, as I said in my written submissions, the council was entitled to say no. That's incoherent, and these two processes at once, so we're not going to do it. But they didn't do that.
No. Okay.
So they must have had some confidence that
somehow
it would muddle through it and.
No, that's fine for now. And I mentioned earlier that we're reasonably comfortable with the natural justice issue, but I did have
all right.
a question on that, but only one question at this stage on that. But we'll wait till you come to it.
Okay. Well,
I've got a question.
You got a question on this? Okay.
One question. And Kaita, who mentioned in their evidence, they outlined a scenario where the relief they sought was that the panel would adjourn until such time as PC19 was issued. Does that align with the first scenario you stepped us through?
I don't think there is any procedural benefit in adjourning as opposed to closing the hearing and getting on making a decision. I mean, just because you close the hearing doesn't mean to say that you can't call for things that you need in the course of your deliberations. So I don't think there's any significance in the difference between an adjournment and saying, oh, well, hearing's closed, we're going to now deliberate. Because under your powers, you can call for whatever you want, whenever you want, until you release the decision. And it's only once you've released your decision, you become partners officio, and it becomes someone else's job to deal with.
Thank you.
Well, thank you for that. Okay. Right.
So I wasn't planning on saying anything more about the natural justice point that is written in my submission, so
the only sort of it's not a concern at all. It's just a matter of understanding how natural justice works. But the PC19 panel will be restricted in what they can decide in terms of scope of. And where I'm getting to with that is somebody who wasn't aware what PC19 could entail could reasonably assume that it's within the ambit of what was applied for under 19. It's not going to lead to a radical intensification of zoning, for instance, beyond what 19 encapsulated. Is it likely to be more minor? The panel is bound by scope, isn't it, in terms of what they can do? Yeah.
Yes. Well, of course, the notified PC19 map is produced under Section 22A report, so you can see what's contemplated there.
Yeah.
Fulton Hogan sought two alternative reliefs under PC19.
Yeah.
But firstly, that it be subject to a future development overlay.
Yeah.
Or alternatively, that it be a combination of low density and medium density residential.
Right.
And it's really that second relief that we say means that it's within the PC19 panel's power to impose what is effectively the residential part of the structure plan that you've got. That they can impose that as part of their decision.
I see.
Now, of course, there's business resource area in PC21 that's not in PC19. So the PC19 didn't deal with that.
Right, okay.
So we still need PC21, even if we get what we want out of PC19.
Oh, yes.
Because
okay. Yeah.
PC19 only deals with residential.
All right. No, I think that answers it. Yeah, I understand.
So from an ordinary person looking at the PC19 submissions, they would have been on notice that Fulton Hogan was seeking a mixture of low and medium density residential for Parkburn. They wouldn't have known about the business part.
No,
that doesn't matter because we're not seeking business under PC19.
That's right. No, that's understandable. Okay with that? Yeah. Okay. Thanks.
Okay. So coming to the NPSUD 2020, it's kind of returning to where we were at the moment, that's page 13.
Yeah.
I set out why we submit that the CODC is a tier 3 local authority under NPSUD in respect of Cromwell now.
Oh.
And that's important for two reasons. Firstly, because that creates an obligation on the council to provide at least a sufficient supply of urban development capacity. And the experts seem to be agreed that even if PC19 is granted, there's going to be a shortfall problem. And that means that the council has a duty to do something about that. So we say PC21 is part of that solution. Of course, we accept and agree with what the reporting officer says, is that doesn't tell you that Parkburn is the right place for that urban development capacity, right? That gets determined through other factors. And in relation to the locational aspect, at page 15, I've dealt with the problem eye to the future master plan process. And so I've set out at page 15 why Fulton Hogan submits that the master plan should not be understood as saying that Parkburn is an inappropriate location. See how many double vendors was there? It doesn't answer the question one way or another about whether Parkburn is an appropriate place to provide urban development capacity. And so the first reason for that is that the master plan is clear that it does not regard Cromwell as a tier as being subject to the NPSUD with regard to tier 3. So at the start, they had a different starting point, and given that it was adopted back in May 2019, so that's nearly 5 years ago now, that's completely understandable. So we're in a different context now. We've got the NPSUD telling us that council has to provide at least sufficient capacity, whereas back in 2019, that wasn't the case. The second reason is that the Parkburn quarry wasn't part of the study area. And so I don't know if you've had a chance to see the documents that I produced in the bundle of authorities.
I've seen the master plan. Is that what you?
Yeah. So what I've done is I've included some excerpts from the master plan, which explains why Parkburn wasn't in the mixed considerations at that point.
Yeah.
And effectively, it assumes that the quarry was going to continue on during the life of the master plan.
Yeah.
And so the priority was to actually set back urban development from the working quarry.
Yeah,
which
that's right.
is perfectly understandable and sensible given the land use conflict that exists between quarries and houses in most of the rest of the country. So it never dawned on the authors of the master plan that the quarry might stop and needs to be and be contemplated as an urban development location.
No, that's right. I did read that in there. I had a question about that though. Is there an assumption that whilst that was ruled out as a potential site and it wasn't commented on further, did the master plan make similar statements about other outlying settlements not expanding, like Lowburn, for instance, or places that are even closer to Cromwell? I mean, how much should we read into that? You know, that this wasn't considered because it is a quarry. Does that help us with whether it's an appropriate location for settlement?
Well, no, it doesn't help you answer the question about this is an appropriate location,
No.
but it explains why the quarry wasn't included in the master plan.
Okay.
And so what we don't know is if the authors of the study thought about the potential for the quarry to be an urban development location at the end of the quarry's economic life, or at some stage, progressive stage in between, what would they have said about that? We don't know because it wasn't in contemplation.
And that's the quarry site. What about Pisa Moorings itself? Like if it was to expand to the south or something like that?
Well, my understanding is that the land to the south of Pisa Moorings is contact energy land.
Right.
But what we can see as a copy of the map in the 42A report, the notified.
Yep.
So if you look at figure 4 on page 7 of the 42A report, I understand that's the notified version. Am I right about that? Sorry, which?
Page 7.
So,
That's all right.
I'm sorry.
Yes, that's correct.
So the notified version of PC 19 contemplated that there would be extension. You can see that Jack's Farm and the PDDL land right next to the quarry is shown as future residential.
Yeah, we haven't got a key, but
Yeah, but the master plan itself, which is what we were talking about a moment ago, doesn't draw down into that level of detail as far as I can recall.
No. So you're saying that because that's shown in PC 19, that should be read as being consistent with the master plan, the rezoning to the south. Is that what you're saying?
Well, I mean, what you can see if you compare figure 4 from the 42A report with the master plan map showing Pisa Moorings, you see that there's a perfect coincidence of where the residential started and finished.
Yeah. Okay.
So what I'm saying is that master plan didn't contemplate whether residential should or shouldn't extend further north than that.
Right.
Simply because it assumed that the quarry was carrying on.
North of it. Yeah. Mm. Right. Okay. All right. And in any event, you've got some other legal submissions about the relevance of the master plan in terms of statutory document and so forth. Yeah. Okay.
I mean, it's certainly a document that you can have regard to, but it's a question of weight about how much weight that you give them to it. A, because it was developed before we had NPSUD obligations.
Right.
And secondly, because it hasn't been through the RNA first schedule process.
Right.
And so we don't know what it might have looked like if there was a formal submission and appeal process that fell out of that.
Okay. I'm happy with that. So, yep, I'll let you move on with that. Thank you. Cheers.
Dealt with ecological effects, which is page 17.
Yep, that's fine. Yep.
Page 18, I move on to the engineer's PL. And what you will see is that the analysis that Mr. Vivian presents in his planning evidence about why the NPS HPL doesn't apply is different to what I said in my legal submission. I'm not saying that I disagree with Kerry's evidence, but there are different ways that you can approach the issue and arrive at the same spot.
Yeah.
So what Kerry does is look at the influence of the scheduled activity area over what the status of the land is under the current plan, about whether it's effectively rural zoned for productive purposes. And he says, no, it's not, because you can effectively dig it up and take it away.
Yeah, I think as a panel, we're keen to know whether there's any legal impediment to us agreeing with that view in terms of, it's not a matter of merits or opinion. There is a way through this, a pathway through, and that's what we're interested in. And I think your legal submissions go there, don't they? They deal with.
Yes, they do.
Yeah.
And so there are two pathways through it. The first is Kerry's analysis, which is that because of the SA 25A overlay, in substance, the land is not zoned rural now.
Right.
As those terms are understood through the National Planning Standards.
Yeah, okay. Yeah.
And that makes sense in a way, because what is happening now doesn't rely upon the fertility of the soil in a productive sense. In fact, it does the very opposite. It allows you to scrape that off and then access the rock underneath. So for that, so Kerry's analysis is that we don't have to engage with the NPS HPL because of the scheduled activity here. And remembering that there's no LUC3 outside of the scheduled activity area.
Yeah.
The analysis of my legal submissions, though, focuses on the definition of LUC 1, 2, or 3 land in the NPS. And so what my legal submissions do is alert you to the words or by any more detailed mapping that uses the land use capability classification.
Yeah.
And so that's what we've had Dr. Hill do, is to use the same classification methodology and apply more detailed mapping for the specific LUC3 area of the site.
Right, that's fine.
Now, what I should alert you to is that there are currently declaration proceedings on foot in the Environment Court in Dunedin in relation to how those words apply in relation to the Dunedin plan.
Right.
We are most unlikely to get a decision out of Judge Stevens before about a year, I would suspect. But if we do, then I'll supply you the copy as soon as it comes out.
All right. Thank you. So it's a two-pronged approach. We'll consider both of those. Yeah.
Yes.
Very good. Fine, that's fine.
That brings me on to cultural effects on page 20. And what I'm focusing on here is the submission from Otago that the proposal should be declined because treated wastewater is discharged into the Kaurau arm of Lake Dunstan.
Yeah.
Now, that doesn't seem to be something that's been advanced so strongly in the memorandum that's been produced by Otago. So I'm not sure to the extent to which it's now a live issue. But what I wanted to do is to alert you to the legal proposition that I want to make, which is that that's not relevant.
Yep.
And it's not relevant in two ways. Firstly, because it's not on the plan change.
Yeah.
This plan change does not seek any kind of permission to discharge treated wastewater anywhere. That's the council's consents that do that. And it wouldn't matter where urban development capacity was created within the Cromwell ward. Under the way that the council's current wastewater treatment works, it would end up in the same place. So that's a matter for council. So applying the machinery movers case, which you will see that Mr. Barr in his planning evidence for PVDL points to, I don't think that the discharge of treated wastewater is an issue that's on this plan change. The second proposition, which is the one that I've developed through the written legal submissions, really borrows from Bristol's consent jurisprudence about the relevance of energy use. And what I've done is included the Court of Appeal's decision in the Ngāti water bottle case.
Yeah.
Where Ngāti were arguing that the disposal of plastic water bottles was something that could and should have been dealt with by the Environment Court as an adverse effect arising from a water taking consent to take groundwater. The Environment Court and the High Court said on that case no, and the Court of Appeal agreed. Ngāti has been appealed, so leave has been given by the Supreme Court to deal with that. But as we sit here today, the leading case is the Court of Appeal's decision. And what the Court of Appeal's decision does is go through the list of factors which allow them to conclude that the disposal of the water wasn't sufficiently connected to the take to be an adverse effect. So by analogy, what we're saying here is that the rezoning of this land is not sufficiently connected to the effects on cultural values of discharges to council's wastewater plant because there are intervening regulatory steps that have to be followed in order for that discharge to occur, whether or not this plan change proceeds. And that is, in this case, council's own consent. So the appropriateness of wastewater discharge to the lake is to be assessed and evaluated through council's consents, not through this plan change.
And that includes ORC, the ORC consent process. Yeah.
Yeah, they are ORC consents.
And can you just remind us, it might be Mr. Vivian, is there an assessment matter relevant to subdivision that would somehow link through to wastewater discharges, or is that entirely for the regional council?
Well, there is an assessment matter that requires the connection of the the assessment require connection to the council infrastructure or does the business? So what, I think the same rules appear in the 42A office report as in various evidence.
Right.
That we've agreed that the residential proposal can't proceed until it either connects to the council's upgraded infrastructure.
Yeah.
And the specifications of the upgrade that have been taken from this viewers' evidence in the PC19 seal.
Yeah.
Alternatively, that there is on-site communal infrastructure that has all of the necessary consents.
Yeah. So what the panel would be interested in is not just responding in a legal context to the concern of iwi, but to actually say how those concerns would be addressed, how we see that they would be addressed through the provision. So it'd be useful if that could be captured by Mr. Vivian and just make that clear to us if you haven't already in your evidence. Yeah.
Yeah.
Thank you.
Well, as I understand the debate between iwi and the council, the choices are the discharge of treated wastewater to the lake, or to take that discharge out of the lake and discharge to land, which is regarded as being culturally much more appropriate. Now, Fulton Hogan doesn't have an opinion about that, because that's the CADC, the Otago Regional Council, and iwi to engage on and come up with whatever solution they come up with.
Okay, understood.
But it wouldn't matter where urban development capacity was provided for, the issue is the same, because if you're connecting to articulated systems, it's value something.
Yeah, we certainly understand that legal point. I think it's more to convey that through the decision. This is what would be interesting.
Well,
Thank you.
And the officer's report and the viewers' evidence in PC19 would clear that the council know they've got a job on hands to upgrade their system.
Sure. Okay.
And the is it 2028 or 2029 current consents? Anyway, the expiry of the current discharge consents isn't that far off.
Right.
A strategic infrastructure planning point of view. So that's an issue that will need to be confronted.
Understood. Thank you. It's just yeah. There we go.
I think those are all the matters that I wanted to address. Some of the issues raised by the submitters will be, and what's been filed, will be dealt with by witnesses as they come forward, particularly Kerry and Dave Smith. But those are matters of evidence and merit.
Right. Well, thank you for that. I understand that the witnesses will address some of those submitter matters, but from probably one legal question relates to the request to include land beyond the PC21 boundaries within PC21.
Yes.
And I'll just signal that I was involved extensively in Dunedin with Variation 2, where I conducted a hearing just on scope, and from my recollection, there were a large number of sites were struck out for being too remote, but there were some that were included that were contiguous or very close to the zone boundary. So I guess the only reason I'm raising that is that did you have a legal reason to try and knock that one out, or you're happy for us to consider it on its merits, that submission?
Well, Mr. Vivian deals with some of the scope issues from a planning point of view.
Yeah.
Fulton Hogan's position, as Fulton entity, is that it doesn't have a position in relation to the zoning of its neighbours' land. It's got a relationship that it has to manage, and it is not this hearing taking that position that you should not rezone contiguous land.
But if for instance, I just thought of one implication of us including that land could be that the trigger points for traffic improvements and it could come earlier through someone else's development and not your own. Would that be a concern?
And that's something that Dave Smith has thought about.
He's thought about that. Okay, all right.
So you should ask him to explain that how those trigger points work from his point of view.
All right.
I suppose the element in the room in that sense is Jack's Farm, because that's got a capacity of 197 lots.
Sure.
Jack's Farm is, my recollection is that the rezoning of that land to residential is sought through PC19, not through PC21. So as we sit here today, my submission would be, you don't need to worry about the potential traffic generation from the Jack's Farm land, because as we sit here today, it's zoned rural resource area. It's not zoned residential. And it would only become zoned residential through PC19, not through yours land.
That's Jack's Farm. I'm not quite sure where that is, but how does that relate to the submission for, was it HISA PS
Right.
PV? Yeah. Is that the same problem? Is it?
If you still got the 40 road, what I to you?
That one? Yeah.
Yep.
Yeah. Yeah.
And so that's the PC19 map.
Right.
So Jack's Farm is the one with the red star.
Oh, I see.
Yeah.
Right.
There is a narrow, I think it's about 10 metres wide strip of land that runs most of the length of Fulton Hogan boundary.
Yeah, that's right.
Which is the PDTL.
That's the one I'm talking
It's
about.
about 8,800 square metres.
Yes.
Yeah.
Yes.
So that strip of land, I don't think is here or there from Dave Smith's modelling point of view.
Right.
Where he landed in terms of the trigger points for the state highway upgrades was concerned with the effects of Jack's Farm development.
I see. Yeah. I'm not sure of what my concern, I guess, was that if we included that strip of land in the PC21 decision, it would create the potential for additional dwellings to be built. And if they were to go ahead of the Fulton Hogan development, it would trigger that, the trigger point would arrive quicker than what you might have, and then the question is who helps pay for the. I just wondered if there was a potential conflict or a concern by if Fulton Hogan for that,
Yeah, well, undoubtedly there is a concern that Fulton Hogan has that the imposition of triggers could potentially give other developers free time.
Yeah.
And it doesn't want to do that.
Okay.
It doesn't think that that's likely to be material in relation to PBDL, because it's such a small area.
All right. Okay.
It's much more of a concern in relation to Jack's
To
Farm.
Jack's Farm.
Because under PC 19, that'd be
Yep.
190 odd sections.
So no one's asked us to include Jack's Farm, have they? It's
No, not through PC.
not through this.
No.
Okay.
And what that means is that neither can you impose rules in relation to Jack's Farm.
No,
Through this
absolutely.
plan change either.
Absolutely.
So where we've landed, is that you should impose a rule, on the Fulton Hogan land, which means that the upgrade happens after the first 270 odd sections.
Yeah.
You can't impose the same rule on Jack's Farm for the
No.
first 50% of theirs.
No.
But it is a relevant matter in the event that that land is rezoned. They will require their own subdivision consents,
Yeah.
and road upgrades, or to be assessed through an ITA at that time.
Sure.
So you don't, so where we get to is you don't have to worry about it.
No. Okay. No, that's fine. I thought I'd put that too because it just occurred to me that it may not have been picked up that by potentially rezoning that strip of land
Yeah.
could have had an impact on the triggers and who pays and those sorts of things. But you're neutral on that, as I
Well,
understand.
we're neutral on whether you
Yeah.
do or do not
Rezone
rezone.
it, yeah. Okay. Yeah.
I don't know that whether you do or do not is material in terms of
Traffic. Yeah. Okay.
But I'd ask Mr. Smith to comment on that.
All right, no, that's fine. And that's your legal submissions. I just had one minor question, I guess, is that I was going to ask you about Colonial Vineyards decision, because in the past I've used that as a framework, a statutory framework for writing decisions on plan changes.
Yeah.
The tests are in there. It's just that in the 42A report and in your own submissions, that there's certain things we have to consider, but it appears to me that in that case, they're neatly laid out in a logical manner. And if I was to use that as a framework for our decision making, would you have any difficulty?
Nothing's changed.
Nothing's changed. Okay, that's fine. Very good.
We've had apps that asked people subsequently. Nothing's changed.
No, look, that's fine. Any other questions on legal matters? And Ms. White, have you got any questions on it? Thank you. I know we spent some time on that, but it might short circuit some of the questioning to follow. So thank you very much for that. How are we going for time? We'll carry on for a bit longer. We haven't sort of scheduled tea breaks, but we'll just take them when we feel they're needed. So, okay, right. Thank you very much.
Yeah, that's mine, sort of coming last thing we had.
I'll just get a break out.
Yes, that's fine.
I'll put it in. That's fine. Oops, thank you.
Yes, I get that.
Right. All right. Yeah, very good. Thank you.
Yes.
So I'm going to ask Anna to introduce herself to you, and she has a summary of 2 minutes that she'd like to.
Thank you, Sue.
I'd like to provide a brief summary of my evidence. So I'll just start by introducing myself. My name is Anna Senkler. I'm a regional manager for Fulton Hogan in Central Otago. As part of my role, I have responsibility for all activities undertaken by a regional business within the Central Otago district. I take my evidence submitted as read, however, I would like to take this opportunity just to summarize the key points. So firstly, about Fulton Hogan. So we currently employ around 300 full-time staff in this region, which serves as Central Otago and Queensland Lakes district. Our expenditure to support the business makes a significant contribution to the local economy. Hogan, I'm sure most of you will be familiar with Hogan and what we do. We provide a full range of civil contracting services. And in this region, that includes transport, water, land development, infrastructure, quarrying, and asphalt production. Playing our part in the community and leaving a positive legacy in what we do is important to us. So why we're seeking to rezone Parkburn Quarry? Our drivers for pursuing the rezoning of Parkburn Quarry are: one, to formalise the industrial processing area, allow for more certainty around plant investments and capital outlay. The industrial area at Parkburn currently includes an asphalt plant and concrete processing activities. Now, these are obviously vital for supporting development and economic growth in the area, as well as supporting building and building maintenance, etc. Two, to provide options for a more centralised base of operations for our business in the future. So currently, our regional base is in Alexandra. A lot of the work that we undertake is in Greytown and Waterca areas. The location of Parkburn is a lot more central to the wider region. So if we were to have a centralised base of operations at Parkburn, this would allow us to efficiently service the broader region and we still maintain a depot and a branch in Alex. It would also allow us to reduce costs and, importantly, reduce carbon emissions from our operations by reducing the travel between our current base and our work sites. Three, to ensure land use after aggregate extraction provides benefits to the region and showcases high quality quarry rehabilitation. So the end use of land after quarrying is an important consideration. Four, to provide a robust framework around which our wider strategy for future business needs, including our quarry strategy, can be developed and implemented. So in conclusion, if Plan Change 21 is approved, it will allow us to plan for withdrawal from extractive quarrying from the site in a considered and staged fashion for the time of trial. It will enable us to continue to deliver high quality aggregates to service the local market and also provide a positive legacy in the future of our presence at Parkburn Quarry.
Thank you. Let's see if we have any questions. Panel, any questions?
In terms of the consolidation of your business in a central location, is this indicated by the industrial development and the yard-based industrial development / office development?
That's correct. So we would intend to have a regional hub, so office and yard within the industrial area.
So in your evidence in chief, you've mentioned that the quarry has up to 20 years of aggregate supply remaining. I was interested in hearing how you see that, how you see the stages working and at what point that quarrying might cease. I say that I note that Mr. Colgrave had estimated that quarrying might continue for the next 7 to 10 years. So I'm just interested in the there's a 20-year lifespan and how that might, from your perspective, how that's going to play out.
Sure. So there is up to 20-year resource left on the site, and up to 20 years of rock essentially left to extract according to our current extraction levels and our current quarrying. In terms of the timing of any future development, there's a number of factors that play into that, namely council infrastructure, so water and wastewater design, for example, consenting of the subdivision. You know, there are a number of factors there that we don't have certainty about at this point in time. So it's not possible to put a definitive time for that just yet.
No, so I appreciate that the definitive time frame is difficult, but is it around the 7 to 10 years as Mr. Colgrave has suggested, or
it could be either, to be honest.
Okay.
Yeah. It's really unknown. It could be 10 years or it could be
sure.
20 years.
Okay, thank you. And my other question was, you've also mentioned that there's sufficient aggregate reserves to effectively service the market exclusive of Parkburn, without any detrimental impact on the price or aggregate availability. Would you be able to talk me through those reserves, the quantum, the location, or what you're talking about there?
Yeah, sure.
Thank you.
So we have 2 other quarries in the region. Clear Lake Quarry, which is Princeton, I love it for it.
What was the name of the first one?
Fairlight,
Fairlight.
Fairlight, this side of Kingston.
Yeah.
So Fairlight predominantly supplies the Queenstown market.
Yeah.
And it's a similar distance from Queenstown as Parkburn is, in terms of supplying Queenstown market. Market Quarry, your market at the moment, it predominantly supplies the Wellington market. However, there are sufficient reserves there that it could supply the wider region. However, our intent would be to establish and consent an alternative or a replacement site, if you like, to Parkburn within a similar vicinity and central Otago market, so that we can continue to supply the central Otago market.
And you've got some sites in mind?
We are exploring those sites more, but obviously we're commercially sensitive.
But uncertain, yeah.
Can't go into too much in detail, yeah.
Okay, thank you.
Thank you. Just thank you for that. The quarry to the north, is that also an aggregate? Does that do the same sort of things that your quarry does? That supplies. Yeah.
It does, yes, at the moment, yes, there's extraction happening on that side as well.
Okay.
But yes, there's an.
Okay, no, look, that's fine. Thank you for your evidence. I have no further questions. Thank you. Wallace, thank you.
Good morning.
Good morning.
I'm having off similar things to what Anna has walked you through, but I think that more wide picture. The one is Bob Willis. I work for Copenhagen as an environmental advisor, providing support to the Central Otago for strategic consenting, risk management, and environmental compliance matters. We'll come back to the strategic consenting in a moment. I've been involved in the development of the proposed Plan Change 21 from the very beginning, and it's included meeting with key stakeholders as we developed the proposal, attended community open days. We had 2 open days over here at Post Moorings to socialise the proposal and refine the preliminary concepts of the proposal. I've also been involved in consultation with a number of the submitters post notification. So my evidence, Chief, that you have read, covers 3 broad issues, namely why and how of the plan change. So I'll just cover, summarise the key elements from my evidence as being our land strategy looks ahead 50 years or further if we can, and it is very much a strategy. So we look as far ahead as we think we reasonably can, and it looks across all portfolios to future-proof business interests. And this includes finding the best fit from an operational perspective. So, for example, regional office hub, and securing the operation of the national plant, and from a land perspective. So that's land for a depot, replacement quarries and such like. The proposed plan change is a key element in this strategy because it provides a clear line of sight for the future of Parkburn Quarry post-quarrying activities. It also intends to provide certainty to the District Council and the community regarding the future use of the site post-quarrying, including the commercial and industrial use. So the proposed plan change is acknowledged as only the first step in a much larger process. It's nevertheless a critical cornerstone of the wider strategy. If approved, it allows planning for a staged completion of withdrawal of quarry from the site, the development of the residential and commercial areas, and the consenting and commissioning of the replacement quarry source, is something that's touched on a moment ago. You'll appreciate that those don't have a fairly long gestation period in some of those processes. So it's acknowledged that the additional approvals and compliance matters exist that must be dealt with in future development. This really is just the door opener. This includes awakening infrastructure upgrades by the Central Otago District Council, the development. Phil's talked about the upgrade of the sewage treatment, for example. Gaining approvals from landowners and affected parties to creating a lake inlet. The need for consents for discharges, for example, stormwater, and approvals for access to the state highway, and road stopping or realignment with Central Otago District Council. And that would include as well such things as formalisation of handing over roading assets once development's occurred, of course. But while we accept that no certainty in any of these yet to be initiated processes, they all rest to a large extent on approval of the overarching plan change as the first step. And it's on this basis that the proposed plan change has been initiated. Fulton Hogan understands that projects of this size and scale have many moving parts. We also acknowledge that there's a degree of uncertainty inherent in such projects and typically a long gestation period for the necessary approvals to be obtained. Fulton Hogan has sought to mitigate this uncertainty through being transparent with the development program and the overarching vision to the site. Because I mentioned we've socialised it fairly widely in the community. So the proposed plan change will provide greater certainty for the development and delivery of the Fulton Hogan land strategy. It's the first step in a larger process to deliver high quality residential and commercial development to consolidate the Moorings residential area. Quarry rehabilitation will be achieved in a way that delivers a significant positive outcome for the social wellbeing of the wider community.
Thank you. Any questions for Mr. Wallace?
Just before I delve into a particular question, in your evidence statement, you mentioned that you're not presenting to us as an independent expert.
Yes.
But then you say that your evidence represents my professional view and is within my area of expertise. I was just wondering if you could clarify for us whether you are here presenting a corporate statement for Fulton Hogan, or whether you're here as an independent expert.
I'm not here as an independent, but I have a long experience in planning, so I see across the various elements of what has been presented by our expert team today. Yes.
Okay, right. So you're not presenting expert planning for the purposes of this hearing. Okay, great. Thank you. I had one question for you. So in paragraph 14 of your evidence, you said that from a regulatory perspective, to have a large aggregate quarry and its associated infrastructure and activity as an immediate neighbour to a large residential area is considered to be a recipe for disaster. Would you be able to just speak to me from that? Is this drawn from your experience with Pies and Moorings? And what do you base that on?
No, it's more broadly. I'm actually Canterbury based,
right.
But I do obviously do care off provide support to the centre of Otago. I suspect you'll be well aware that that quarries typically generate a lot of heat when they are proposed, and the further removed they are from residential zones or even residences, the better. And typically, we see arguments around the Australian standards, 500 metres linear separation, and what is the number? And so someone's always looking for that number. So to have a situation where we have an existing quarry and we have then high density and high value residential development built effectively right up to the boundary, you would think would be, experience would suggest that council would receive a lot of complaints on a regular basis about the noise, about the dust, about all the aspects of quarry operation. In fact, we see very, very little of that here at Pies and Moorings.
It's through your monitoring program? Through your monitoring program?
Through, well, just generally speaking, we're not getting, council's not receiving any complaints like that. Well, I'm not sure of the number, but we certainly have a very, very low level of dissatisfaction of what's occurring. We monitor very closely. This quarry has been set up with an example of quarries in the future, so we've invested significant resource into bringing in latest technologies to the operation of the quarry. For example, our mist curtain, and we know from monitoring we will have more dust flow in from the north than exits the site from the south, even though we're currently quarrying in the site. So that suggests we're actually reducing the level of leaks from what exists just naturally around the site.
Thank you. And one last from me.
Sure.
Did you have a chance to review the submission, the evidence by HWR, where they're now seeking to amend the structure plan to rezone some of the site which adjoins Lake Dunstan to residential resource area?
I've had a look at the evidence. I don't think I would necessarily like to comment on that, except to say perhaps that when we initiated this process, the land was in fact had a different landowner. HWR has only recently acquired it, when we were initiating this process, we reached out to the landowner at the time and said, we are currently developing a proposal. Would you like to join with us? Do you have any issues that we should consider in developing our proposal? Unfortunately, of course, we moved to a point where HWR became involved, that we were beyond being able to address any concerns, whatever they may be. So we have endeavoured to get information as we go along.
Sure, and Mr. Vivian will be talking to us about, talking us through that as well, I expect. Thank you.
Thanks, Mr. Wallace. Just one question. I was just interested to know whether Fulton Hogan or yourself have got any experience of quarries being rehabilitated elsewhere around the country. Has anything like this happened in your experience with a development of this size and scale?
Only to the extent that there would be 80 or 90 ex-quarries in Christchurch City, which now house residential or commercial development. So for example, Fulton Hogan our main Canterbury, because the Hornby is built in the old quarry.
Is it? Okay.
It actually occupies the quarry, so part of it, it's actually in the whole, part of it's around the periphery. So, but as Christchurch has grown, it's absorbed and built over the top of the quarry. So some of these have been completely filled, some have been partially filled, some have been used for detention basins. In fact, it's fair to say some are recreational areas that are well used, well loved, but our Hornby yard would be a good example of an old quarry being used for industrial use, I guess you have.
Okay, very good. Yeah, I might ask Mr. Baxter the same question, whether he's been involved in similar things, but it's interesting to know. Yeah, thank you for that. Now, in terms of proceedings, we're hoping to have lunch around 12:30, so we'll probably take a tea break now, but not a long one. We'll just, I'm not sure what the arrangements are. I think people might have to make their own arrangements for that. So if you wanted to get takeaway coffees and bring them back in, or 15 minutes, was what I had in mind. And I'm conscious we've got two gentlemen online waiting to come on. So, and Mr. Baxter, and we were possibly imagining Mr. Vivian would be on in the afternoon at 2 o'clock. If we don't get to him in time, we've got a slot there for an hour and a half. So we'll see how we go. But yeah, if we come back in 15 minutes or so, that would be good. Thank you very much. Okay. Right, thank you, folks. We'll carry on with the hearing. Witnesses.
I'd like to introduce Paddy Baxter to the panel.
Thank you.
Because Paddy's a landscape architect, we have many things to look at.
Oh, that's great. Yeah. Thank you. Oh, yeah. Thank you.
And present summary of the evidence. It's going to be a written form, so you don't have to take notes as you go.
Oh, excellent. Thank you.
Thank you, Chris. My evidence I've just put in the form of bullet points.
Right, that's fine. It's perfectly fine.
Have you got the
Yes, you've got that. Yep.
But basically, it's a shortened version of my evidence, and it follows the headings of my evidence. So I'll go to number 2. The site is an operational quarry and has been since the 1980s. The bulk of the quarrying operations have taken place in the south of the site, leaving a substantial man-made depression in the south side, the lakeside landform remaining in place, which we'll talk about. There was an effect of farming, quite a substantial one on the lakeside. The northern portion of the site remains largely intact, aside from a utility area in the northeast corner, with the park and stream access in the northeast corner of the site. The existing vegetation is sparse aside from Brown Creek, that creek, and the state highway roadside boundary wall is budding and planting. So on the landscape of those patterns, you can see the requirements of the operation requirement. By political residential context, the Paisumorian residential area, to establish residential arrangement borders the south boundary of the site and extends south to the location where the butts comes from the reserve and the lakeside. And that's essentially filling that land available for residential development between Cromwell and the southern boundary of the site. And I think it's an interesting point to make. From my observation, all the land could have been turned into residential land between Cromwell and the Parkburn quarry has been converted to residential land.
Okay.
Yeah, aside from outstanding consents at Jack's farm.
So in terms of zoning, in terms of available zoning, it's all being developed. Is that what you're saying?
Yes,
Yeah.
yeah.
Okay.
There's a bit of contact energy land
Oh, yeah.
down south, and then there's that sort of Dolphin area, which is the council reserve. And then once you get to their surface, basically it's the state highway 6. I'm talking about land east of state highway 6.
Yeah, sure. Yeah.
Everything east from there down is actually on the lakeside.
Yes.
Yeah. So just an observation that I made.
All right. Thank you.
The piece of mooring residential, the residential area on the southern boundary is approximately 15 to 20 metres in elevation above the excavated southern portion of the site, and that's at its highest point. It varies. And then referring to guides and moorings, for inland waterways directly connect Lake Dunstan and Lake Caterpillar and the hydro model development with a continuous cycleway/walkway around those edges. Continuing along the eastern side of the edge of the site on the western side of Lake Dunstan. From what I understand, those small inland waterways were constructed at the same time as the excavation or the cleaning up of pre-construction Lake Dunstan was being undertaken, and they were there by default, basically. They filled it up and filled those up as well. Then immediately north of Fulton Open Quarry exists another green, and that's been discussed this morning. North of that is a continuous established amenity of vineyard, and probably my attachment A shows that north of that is a continuous established amenity of vineyard and orchard/cherry operations, some with public access for activities associated with those operations, and by that I refer to small retail centres or wineries, etc. West of State Highway 6, the landscape is largely a vineyard landscape, and that's occupying flat land which immediately adjacent to State Highway 6 and also located over the, recesses type of that. That should have been the terraces of that landscape. The scattered residential development and horticultural structures. That landscape remains essentially rural character. The master planning process was begun in late 2020, early 2021. And I think in the original application you saw part of the conceptual process that's been undertaken. The design of the proposed development has been influenced by the shape of the land, and that's largely arising from the quarrying operations and its location adjacent to Lake Dunstan and access opportunities from both State Highway 6 and Peter Mall. In just about a minute, we were having a discussion over the break as to where else that this could possibly occur in the South Island. And if you think of the hydrolats of the Mackenzie country, well, two impediments to that is the scale of the drawdown, you move between 4 and 12 metres, and the outstanding natural landscapes.
Yeah.
We moved north or south a lot of the lakes within the national park context. The only place we can think of this occurring could be Lake Aviemore, which has a similar drawdown. However, it hasn't got an 60-year history of removal of quarrying. So we started on this piece of land with a flat site at its full original contour. The substantial cost and scale of excavation are required to prepare those inland waterways would negate any profit or any, in fact, it would be costing us. So I just point out, and from a designer's point of view, this was this made the jump particularly interesting because of the unique opportunity that we have.
Okay, thank you.
The goal of the design was to fully utilise this unique opportunity arising from the above points, and this is enabled also by the relatively small and consistent operating range of Lake Dunstan. The opportunity to terrace or grandstand the layout of residential development, and this is the southern part, around the southern portion of the site has been fully exploited. Noting also that the benefits to those existing residential properties on the northern edge of Reed Moorings. And so in regard to their outlook, the amenity will also be substantial. Fundamentals to the design included connectivity with adjoining properties which fits comfortably into the plan, maintaining an appropriate balance between open space and residential form, and an understanding of the design principles required to adhere to in order to maintain water quality within the site, and the opportunity for overland treatment runoff to be expressed by way of wetlands and passive ecological treatment. Also important, I note here that I do also acknowledge the support of the applicant to weave a significant ecological overlay into the design, giving rise to ecological benefit and a high level of aesthetics and amenity. I work for a lot of master plans, a lot of developers throughout the country, so it always makes one's job easier when the client, the landowner, is fully supportive of the vision to the original to enhance the community and aesthetic, and that's the experience of that with this process. The master plan form and layout. The Southern Valley will become the focal point and heart of the development with the village centre, with accompanying boating facilities, apartment buildings, comprehensive line, and a small commercial area located at the east end of this valley adjacent to Otago. The removal of the existing bund preserved the screen of the existing at the time of that quarrying operations from eastern views will also allow views from this valley, those views up to the lake and beyond, opening up to that valley. The proposed waterway locks to the west are being planned to be located approximately 3 metres above the operational level of the lake, with public access to be maintained along the water bridges. Proposed access point from the State Highway, which is adjacent to the valley. The village centre is the heart of the development, within comfortable walking distance from the bulk of the site. A small sheltered north-facing and vibrant Woodstone precinct with an appropriate mix of built form and open space, providing a high-quality destination for residents within the site and for residents within the existing Moorings residential zone. And it's easily accessible by vehicle to site forward. The scale of the proposed commercial zone that's described in my primary evidence, and it's carefully set out to be of a form and scale to provide limited retail opportunity without detriment to existing formal town centre retail viability. Proposed lot densities, and this section is taken directly from my primary evidence. Plan change 21 sets a limit of 543 residential allotments in total for the area. And that was calculated from my attachment A on this. So I do have I can spare A for his copy.
We'll have one in front of us in a minute. Yep, thank you. Yeah, we got it.
And that's where that calculation came from.
Oh, yes. But hold on, we'll just get that. So it came from E, wasn't it? So
we might not have E.
oh, okay. No.
No, we don't have E.
Bottom right hand corner is the plan.
Yeah, we don't have that one in front of us right now. Can we?
Yeah.
And so, yeah, just take us through how that was calculated it's based on the zonings in this plan, or based on, there's a lot yield. That's right. I remember seeing this. Yep. Okay. Do remember seeing that.
That was based on that mix there.
Right. Okay. All right. No, that's fine. That's understood. Thank you.
On that master plan, the following pattern was suggested. Large residential lots around 800 square metres. That's in the vicinity of and surrounding the proposed waterway. A mix of lot sizes over the wider portion of the site in the order of 301 to 799 square metres. Then opportunities for high density lots and comprehensive housing in the northern portion of the site with access to open space. In the apartment and then apartment development around the village in that waterfront area. Since that was done, when this was first done, then the structure plan was set out and the of the provisions plan change 19 were brought into wrote a late into the structure plan. So I understand that this plan change 21 proposes a broader overlay of the ROA, the ODP, low density residential going over the bulk of the site. There are small areas of medium density residential areas are proposed around the village to allow for densities down to 250 square metres. I consider that approach as reasonably generic, and there should be flexibility at consent stage for possibly smaller lots and comprehensive development within lower density area, and that will be responding to the market need for more comprehensive and affordable development in that area and to offer a range of buyer choice. Having said that, I do understand that proposed changes to the wider residential zones and plan change 19 do accommodate this, and once that is confirmed, we'll apply to plan change 21. Green space and stormwater management. And there I understand that the water quality, health and the sustainability of the proposed waterway area is fundamental to the viability of this development, and that consent will be required from regional council. Taking this into account, there's an opportunity to express this fundamental requirement by way of overland water treatment, and that would incorporate a mix of wetlands, water filtration gardens, swales and other design tools. Those all of which will add considerable amenity to the development, whilst also serving an important ecological function and protecting water quality. General form of these are shown on the master plan, essentially taking advantage of the general features of proposed waterways, slowing runoff velocity down and enabling substantial areas of additional abundance that are adding value to the wider aesthetic of the development. Connectivity options described in my primary evidence. In short, all the linkages are in place in the boundaries of the site for connectivity, and those are existing linkages by way of vehicle and for cycle or activities. Within the site, the opportunity for a high quality internal walkway cycleway network that's in place and shown on the master plan. Therefore, importantly, public access will be maintained to the majority of the water reaches, with an opportunity for access through the future wetland system, giving users a rich and diversified experience. By way of that, we have shown you the lock boundaries on the waterways extending right to the water's edge. And then there are obviously other places like in the boating facilities areas where public waterways have to be moved back to safety. Then you have a copy of the alternative plan.
Yes.
Yes, well, it's been sent to the panel on Friday, and they have it, and so if you could explain why you prepared this and what you would like them to observe from that.
I was instructed to prepare a plan for a development which was still using the form and scale of the existing quarrying operations, but should consent not be able to be obtained for connection to Lake Dunstan, how would it look?
Oh.
And so these I've shown a connection of ponds and wetlands. You can see on each small return on that central pond area, there's a wetland above it. So really, I think there's an opportunity here for overland water disposal to run through a series of wetlands and down into the pond system. These are ponds formed out of gravels, fairly similar to the Clearwater development out of Christchurch, which is also which is alluvial water, basically with water moving through gravels. Yeah, but it still maintains it still respects the form of what the original design took. I do notice that, of course, this would also allow for the fact that on the eastern end, we would be removing that fund. So, and there's a really strong visual connection from the whole development valley out to the east, out to Lake Dunstan. I also note that this was an indicative plan prepared in the last week, and I carefully looked down the bottom, final lot numbers are subject to zone provisions. So it generally shows the shape or form, but I don't think you should be counting the lot numbers.
What we want you to understand with this is the zone structure plan that's in the PC21 documents.
Yeah.
What Paddy has drawn here in this plan would fit that zone structure.
Yeah.
So
Right.
what we were doing is imagining that you might ask us, well, how can we have a structure plan that shows a connection to a lake when you told us that you're not allowed to take it into account because we have resource consent for that? Well, this is the answer to that question.
Right. So if I've got that right, I think I've got it in front of me, the zone structure plan. I think that's the latest version.
This one? Yeah.
Yep. So that while they show a different that shows an entrance, that would still work without that, because this is how it would look in terms of zoning and so forth. Yeah. Okay. All right. That makes sense. And I did have a question for Mr. Vivian, which I'll ask later, as to how the structure plan is given effect to through the provisions, and I'm sure he can take us through that. Thank you very much. Yep.
Just one more point. Hans was speaking about other quarry developments.
Yep.
Clearwater wasn't a quarry development, it was an integration. There's a couple of small quarries there, but they were the size of this room. And I was involved, John Darby Richlands.
Yeah.
But despite the one of the Three Kings Quarry development, which I wasn't involved in, but I'm aware of, and that's up in Auckland, and that's undertaken by Fletcher's. So that's the Three Kings Quarry development.
Oh, yeah.
And that's 1,500 lots.
Okay.
And that occupies a very large quarry.
Yeah.
And historic quarry up in Auckland.
Excellent. Yeah, thanks for that. All right. Let's see if we have any questions. But bearing in mind, we're going to have a brief site visit. We may have some questions after lunch. I'm not sure if you'll still be here. Okay, great. Okay, thank you.
So it's been suggested that in the Section 42A report, and I believe Mr. Vivian has concurred, that beyond the wetland and stream areas, there's no guarantee that the further ecological restoration will be undertaken. And I'm interested in whether that has any bearing on the conclusions that you've reached in your assessment.
Well, that's a pretty broad statement, because there's two halves that one landowner wants to undertake it, and it's my target one that, and two, the process that we have to work through with the regional councils on. And say that the wetland process, firstly, the streets, from what I understand, will have this way of wetland rain gardens in all the streets.
Yeah.
The wetlands that we require the area of wetland that is required to maintain the water quality. So to say it now without undertaking that study, to say it's going to be fixed to what's shown on the plan.
Yeah.
Is largely relevant. It could be a lot more.
Yeah.
Does that answer your question?
Yes, I think so. Yes, thank you.
Yeah.
In the scenario where consent wasn't granted by the regional council for access to the lake, how will water be cycled through the ponds?
Oh, we're still, well, that's got to be worked through. There are articulation and recirculation options. And also bear in mind that we have a reasonable migration through the existing gravels, which you see direct down the bottom of the site. You can see the ponds, it's actually lake water in there. So the lake water that does move out very slowly. But I believe that without connection to the lake, the ratio of wetland to open water will need to be increased substantially in order to maintain water quality.
Mr. Chairman, can I just add to that, that irrespective of exemplary required in the Otago Regional Council for discharge school area, whether it's through opening the local lot. So that again, that's part of the next step once we through stage one before we develop the curve.
Right. Okay. All right. I had a couple. You finished the answer? Okay. The questions I had in terms of the yield, the plan you showed attachment E. I noticed there's medium density lots can range from 301 to 799, 300 to 800 square meters. That's quite a wide range. And have you sort of taken an average somewhere in the middle there to get to your 272? Is that how you've done that? Or?
No, the 272 basically expresses the number shown on this lot, on the master plan here. Some are 301 and some are 799.
So you've just used your judgment as to how you would develop it if it was you designing it. Okay.
Subject to market forces, but I believe that you're probably going to end up with a 300 ones, ideally closer to the village centre, the high density.
Right.
To have an increased density closer to the village centre.
Yeah, and is your intention to have larger sections near the lake edge? Is that to do with sort of amenity, providing more open space, or is there any other reason for you doing the value of it? Okay, all right, okay, that's very honest. Yep, that's fine. Okay, to see if I have any other questions. I suppose the only other question I had was in relation to the submissions we've had from adjoining landowners wanting, some form of change to the zoning in terms of the strip of land you will have heard about PV, Pizza Village, and also the rezoning to the northeast, I guess, to provide residential zoning instead of commercial or business zoning. Have you got any thoughts on that from a design perspective as to how those might integrate or affect your master planning design if we were to agree with those requests?
Well, I think master plan as it stands at the moment, with the industrial area to the north and the buffer zones, does fit reasonably well with any future development on the quarry site from north.
Yes.
For the simple fact that we have a buffer zone between that housing group, and which provides separation from the industrial area, and then that the industrial area on the north side of the site is on the southern side of any future development which may occur to the north, which is the right place there. So their outlook for well-being is also all to the north. And then, of course, we've got the natural delineation in terms of land use for the vineyard and intensive agriculture.
And that strip of, we haven't heard from the submitter yet, but the strip of land that they're requesting to be included to the south, I'm trying to work out whether is it that strip that's just next to all of where the properties end. There's a very narrow strip. Is that a?
Yes, you can see a little line on exactly that plan you're holding.
Yeah.
There's a narrow.
And that's right by the bunch.
Right, well, not right along, but yeah.
So that's less than the width of a normal section, and it's right against the bund, isn't it? Is that right? So,
yes.
Yeah.
So typically there's a cross and I don't think it's fun. So he did have a resource consent process for Laneway and subdevelopments.
All right, no, look, that's fine. We'll ask questions about that, but
it's not an ideal size for residential.
No, that's okay. Thank you for that. I think that's that's that one. Oh, geez. You've answered all my questions. Thank you for that. Thank you very much.
I'll still be here this afternoon.
All right. Okay, something might pop up on our site visit, but that's fine. Thank you. All right. Okay, I think we're ready for the next. Thank you.
So the next two witnesses are both online.
Yep.
I have no such view about which order they should occur.
No.
The case that we can see on screen.
Yep.
Our traffic expert.
Sure. Okay.
Yes, good morning.
Written summary of evidence.
Okay.
You've got that?
Yes, I do.
You do,
Yep.
Tara.
We'll get that and
And he will be able to update you about what's happened with the caucusing was Whakataha.
Right, okay.
And he may be able to
Thank you.
comment on whether it makes any difference to his calculations, whether that PDD of strip is rezoning or not.
Right, we're starting to learn more about that strip as we go, so it'll be interesting. Thank you.
Are you happy for me to read through the summary statement?
Yes, that would be good, thanks. Yeah, thank you.
Okay, sure thing. I'll start from paragraph 3.
Okay.
I prepared an integrated transportation assessment following the receipt of submissions on Plan Change 21 to assess the potential transportation-related effects of the plan change on the transport network. I concluded that if the recommendations put forward in my report were adopted, the safety and efficiency effects of Plan Change 21 on the network can be appropriately managed through the future subdivision consent application processes. My ITA recommended that the master plan is amended to include at least 2 indicative transport connections to the northern boundary of the site. I note that 1 existing and 1 new connection are provided in the Parkburn structure plan, which satisfies this recommendation. I recommended that Fulton Hogan engage with Pisa Village Development Limited and secure a transport connection to Pony Court to support connectivity with the existing Pisa Moorings development. This is also included in the structure plan. I recommended Fulton Hogan seek ongoing engagement with Whakataha with respect to future upgrades to the State Highway 6 Pisa Moorings Road intersection to be upgraded to a single lane roundabout, or to have restricted right turns and alternative access through Plan Change 21, and upgrade the State Highway 6 8B roundabout to a dual lane roundabout. Following the completion of a comprehensive traffic modelling assessment using Council's Cromwell traffic model, I concluded that these 2 state highway upgrades should be in place prior to more than 50% of residential development being established. I note the plan change includes Rule 733(1)(c), which restricts the overall number of lots that can be developed on site, and Rule 736 Roman VI then J, which limits the quantity of development that's up to 50% of the residential development until such time as State Highway 6 8B and State Highway 6 Pisa Moorings Road intersections are suitably upgraded. Paragraph 7. Mr. Baxter has presented amendments to the master plan, and just to be specific, this was Mr. Baxter's alternative should a waterway connection between the development and Lake Dunstan not be established. In his summary evidence with respect to the connectivity through the residential portion of the site, I have reviewed and discussed these amendments with Mr. Baxter and can confirm I support these with respect to connectivity and the operation of the site from a transport perspective. Clarification around the development threshold. So the transportation modelling that has been undertaken to determine how much development I can support prior to the state highway upgrades considered the cumulative effects of traffic generated by Plan Change 21 and the adjacent Jack's Farm development. I understand the potential yields of Jack's Farm, should it be zoned as medium density residential, is 192 lots in addition to the 543 lots proposed through the plan change. My conclusion that 50% of the development could be supported is informed by a model run that assumes that 50% of Plan Change 21, that is 271 lots, and 50% of Jack's Farm, that is 96 lots, were established. Subsequently, the cumulative impact of 369 lots in total were assessed, and this, in my view, is the threshold at which the State Highway 6 8B and State Highway 6 Pisa Moorings intersections require upgrades. With respect to the Fire and Emergency New Zealand submission, I have addressed the matter of minimum vehicle crossing widths in paragraphs 55 to 57 of my primary evidence. And I understand that the desired 3.5 metre minimum width is met by Council's engineering code other than for a single lot served by a right-of-way. I've recommended that for the avoidance of doubt, I would support an amendment to the plan to address this scenario, and note that Mr. Vivian has amended Rule 733 in that regard. I support this amendment. New Zealand Transport Agency Waka Kotahi. I note that no formal evidence has been lodged by Waka Kotahi. I have engaged with Waka Kotahi on the 8th and 9th of February to discuss any outstanding concerns arising from their submission. Mr. Vivian and I engaged in informal conferencing with Mr. Johnston, who's their senior safety engineer, and Waka Kotahi planners on the 9th of February. At the time of preparing the summary, we are still working towards a signed joint witness statement. And an update there is that we've, in my view, resolved any technical issues and planning conditions thereof, and we're just down to sorting out a couple of typos and getting the statement signed. So I imagine that receiving that, it'll be imminent. Paragraph 12. I understand that there are no outstanding matters of concern in relation to the safe and efficient operation of the State Highway, subject to the following amendments to the planning rules. Upgrade of the existing northern access intersection prior to industrial and or residential development occurring on site. My understanding of the nature of this upgrade is limited to improving the left turn deceleration lane, so that's the southbound lane, bringing it up to current engineering design standards. And the standards themselves are mentioned in the joint witness statement, but essentially it would include providing some separation between the existing left turn lane and the southbound through lane, so that there's it improves the safety of the intersection by widening the carriageway by about 3 or 4 metres. So it's a fairly straightforward improvement. Item B, the establishment of the connection between the site and Pony Court. And this is to avoid short local trips from occurring on the State Highway between Plan Change 21 and the existing Pisa Moorings development. And that should occur prior to residential development on site. Item C, the establishment of a cycle connection between the Plan Change 21 site and the Lake Dunstan Trail to provide a safe alternative to cycling along the State Highway, and this should occur prior to residential development on site. I support these amendments to the planning rules and consider there to be no outstanding points of disagreement between myself and Mr. Johnston in relation to the plan change. Paragraph 14. I have reviewed submissions, the Section 42A report, submit as evidence, and amendments to the Plan Change 21 Master Plan and plan provisions. I consider that all matters raised are satisfactorily addressed by the plan change or can be addressed at subdivision consent stage. I remain of the view that the plan change can be supported in relation to transportation matters.
Thank
you. Would you like me to address the PVDL matter in terms of the thin strip of land?
Yeah, sure. Yeah.
Okay, great. So I've had a look at Mr. Barr's evidence, and I understand that the land area is 9,011 square metres, so it's just under 1 hectare. Based on the modelling that we've undertaken to assess the wider effects on the network, for medium density development, it worked out to 16 households per hectare. So if the same rate were applied to that roughly 0.9 of a hectare, then there'd be potentially an additional 15 lots. Now that would generate in the order of, based on the rates that we've used in our assessment, in the order of 1 additional vehicle movement every 4 minutes from those 15 lots. So it's about 2% of the level of trip generation that has been assessed on the plan change site. So in my view, that addition of 1 vehicle every 4 minutes is likely to be not noticeable to road users and would have a negligible impact on the wider network.
Okay. I'll ask you a question on that before we go back.
Sure.
Understand that point, but how does it affect the triggers? Will it bring forward the need to do by 15, let's say 15 units? Will it bring forward the timing for doing the improvements on the network as a result of that thin strip being potentially developed before the Fulton Hogan development goes ahead? Is that something that probably doesn't concern you in terms of whether the intersections will work or not, but would it have that effect, do you think?
Well, my understanding is that there is a threshold included in the rules that are presented in the plan, and that is the 271 lots. So if this were to be included as part of the plan change, then that would be part of that 271 lots.
Yeah, okay, that's fine, thank you. All right, I'll see if we have any questions on your other evidence. I'll go to the panel first. Thank you. Anyone?
I'm not sure where to look with this camera. I think I need to look at this.
Oh, yes, good point. Good point. I think we do look at that.
Thank you. I just had a quite a generic question, I guess, for you in terms of provision of public transport. I think you did make some comments in your evidence around that. Is it unusual? I guess what I would like to know is, for a development of this size, would you normally expect linkages with the public transport infrastructure?
Yeah, it's a good question. Yeah, public transport is a challenging one. There's currently no services whatsoever in Cromwell, which currently has roughly 8,000 people included in it. So it is a matter for the regional councils. It's a matter of whether public transport services can be established, and whilst it's very rare for a public transport service to actually fully pay for itself, even with subsidies, it may be very difficult to be able to recoup a substantial amount of the costs of providing that service. So yeah, it's a real challenge when you get out into some of the smaller urban areas in New Zealand. There are examples I'm aware of where communities have gone to the regional council and said, look, we want a public transport service. And there are mechanisms such as targeted rates where the community is comfortable with that, to be able to help to subsidise the cost of providing those sorts of services. In this particular example, I think it's very helpful that both Ritchie's and Intercity have services that connect Cromwell to the wider region, with the Intercity connecting back to Dunedin, connecting to Queenstown, Ritchie's connecting Wanaka and Queenstown via Cromwell. So there are services as such. It wouldn't be a huge stretch if there was sufficient numbers in the Pisa moorings area to have a stop, so that service that comes down from Wanaka could potentially duck in, pick people up, move through. That's obviously a commercial decision that Ritchie's would have to make as part of that service. So there are options. And look, from my perspective, the engineering standards in terms of providing primary roads through a development such as Plan Change 21 would be able to accommodate bus movements through the development, should that be required either by a commercial operator such as Ritchie's or through a service that was provided through contracts from the regional council.
I think thanks very much. That's really, really helpful. And another question I had, in your evidence, you suggested that the pedestrian cycling behaviour patterns, you don't anticipate them to be very high. Could you just talk me through that, on what reasons you expect that? As I guess I'm thinking of this wider kind of behaviour patterns and cycleways and a big uplift in cycling. Why do you think that's not going to occur here?
Yeah, so that comment was made in the context of connecting through to Cromwell. So it is roughly an 11-12 kilometre trip using the Lake Dunstan Trail, which is, I mean, it's great having the trail there because it is a fully separated and safe facility. It connects directly into the town centre, which once again is fantastic. The context of that was really thinking about daily commuter trips. I know some people that do commute that far by bicycle. Yeah, for a lot of people that will be just too far. It will be an impediment to biking every day. So can the weather and other factors as well. I do see there being an excellent opportunity here, particularly with the connection through to Pony Court, to be able to support walking and cycling between Plan Change 21 and the wider Pisa Moorings development. So I certainly don't make that assertion in the context of those local trips. This will actually enable that and be designed with that in mind.
Well, thanks. Thank you.
You're welcome.
Very good. Yep. Okay. Thanks. Okay. Thank you. In terms of the two accesses into the site, there's one existing and there's two existing ones to be substantially upgraded. The southern one. What is your assessment of the split of traffic between those two accesses going into this development? Which one would take more traffic, do you think?
Oh, I could pull that up from my ITA if that's helpful. If you just give me one moment.
Or even just a generic sort of comment about which is the more busy one would be useful. But if you have that information.
Yeah, certainly. Well, the purpose of the two accesses will be a little bit different, and that depends on that's in relation to the zoning that's put forward. Yeah. Sorry, not the zoning, the actual development areas within the structure plan, noting that the industrial area is at the northern end of the site and residential is through the middle and the southern end. So there's different trip patterns associated with that, with the industrial access. So the northern access, yes, there's connectivity through there, so residents can use it, and they may favour that to be able to turn right if they're heading up towards Wanaka. But the majority of residents would use the southern access to turn left and head down to Cromwell and other destinations. Industrial traffic, though, would almost certainly exclusively use that northern access.
Right, and in terms of the improvements to the southern, I think you talked about the deceleration or the left turn lane in from the north. Did you mention anything about a right turn bay? Is that envisaged, a right turn bay to get into the access, or is it to be a roundabout?
So we'll start with the northern access, which is the existing one, which accesses the quarry. That currently does have a right turn bay. For northbound traffic, so that's all good. So the improvement would be for the left turning traffic coming in from the north, from Wanaka. And it's a fairly minor improvement in that it adds about 3 or 4 meters of width. Just as perhaps a wee bit of an example, the new intersection up on Gippsland Valley for the residential development there, that aligns with the new engineering standards. There's another intersection, the Jack Hanley Drive down in Jack's Point is another one. So they're good reference points in terms of what that might look like. And I'd envisage that the southern access, which is yet to be formed, that would require the same engineering standards to be met.
Oh, I see. Okay. I may have misunderstood that, but thanks for clarifying that for me, because that will clearly take a substantial amount of traffic in through that southern access for residents especially. All right. Just see if I have any other questions. In terms of the cycle connection, you say to establish a cycle connection, is that just to be a legal connection or a formed cycle way? Do you know, is that part of your brief to look at that, or is it?
I haven't thought about the legal status of that connection. The Lake Dunstan Trail currently goes all the way out to Smith's Way, so it goes past the entire site and then continues on north about 1,500 metres, 2 k's or thereabouts. From my perspective, it would probably be a matter of discussing that with council. But I certainly support that connection being in place to provide that safe facility.
Right, that's right. It's probably to be dealt with at the subdivision stage, but there will be a connection in your assessment. Okay.
And there are options there to have a easement over private land if it was on private land. And easement for public access is not uncommon in those sorts of situations.
Right. Now, the other thing about the State Highway roundabouts, is it State Highway 8? I've lost it now. The one where the joint witness statement is going to deal with an potential upgrade to dual lane for that. Which roundabout is that? Is that the first one you come to when you're heading from Wanaka as you approach Cromwell, or is that the intersection we're talking about?
Yeah, so State Highway 68B is it's a fairly new roundabout. It's been operational for in the order of about a year or so.
Right.
So it is that single lane roundabout at the northwest edge of the town centre. So it's the first one you come to if you're coming down from Wanaka or up from Queenstown. Yep. So that is the one we're referring to, and that's represented through the planning provisions.
And in terms of dual laning, does that require more private land, or is there enough reserve for that? Do you know? We probably haven't done designs yet, but does there appear to be enough land to do that without encroaching on private land?
Yeah, I haven't looked at that specifically, but I'm happy to do so and report back.
Well, I guess I'm only just exploring if there are any further impediments, but the way this has been presented to us is that would be a required work, and it's possibly not for us to consider it much further than that. But I was interested to know whether it can be readily done, but that's okay. I'll leave that for now. Thank you. Right, let's look here. And the speed reduction, the potential speed reductions through Cromwell to 80 kilometres an hour. The way I read your evidence, that would potentially be a consequence of PC21, wouldn't it? The additional traffic. If you viewed it in the manner of that's something that would be required with any residential development on the network, it's not something just caused by 21. Is that how you viewed it?
Yeah, that's right. It's somewhat of a chicken and the egg scenario in terms of reducing speeds as urban areas develop. A reduced speed at the key intersections along the corridor would obviously improve road safety. And as newer urban areas develop, it provides the rationale for reducing those speeds. It's not a matter for the developer or the plan change. It's purely within Waka Kotahi's jurisdiction. But I would expect that a speed reduction would be consistent with the environment, particularly if more urban development were to occur and more intersections were to be formed on the highway.
Thank you. I have no further questions, so thank you very much for that.
You're most welcome. Thank you.
Thank you. Right, we'll carry on. Thank you.
All right. And possibly our last for the morning.
Yeah.
Today is our soils expert, Reese Hill.
Oh, yeah.
And then good morning, Reese, or perhaps afternoon, I'm not sure which.
That's very close.
Good morning. Good afternoon. It's just clicked on 12 o'clock by my clock.
Thank you.
So I have prepared a summary of my evidence, a very brief one, and if you're comfortable for me to run through that.
Yeah, that's fine. Thank you. That'll be fine. Yep.
Great.
Yep.
I may add some additional points of clarification. So my summary refers to my pre-circulated evidence, including my soil and land use capability classification assessment report. And the key points that there's several sources of regional scale soil and land use capability and map information available for the site. Most of these, or all of these, are at least in part kind of stem from one soil survey that was done by Lemmy and Saunders back in 1967. And of these, the 1 to 50,000 scale LUC or NZLRI land resource inventory and map information, that provides the only direct correlation with the soils and the land use capability units for the site. The NZLRI identified and mapped an area of LUC unit 3S4, which is land use capability class 3, which occupied around 11 hectares of the site up in the northeastern corner there. And based on the National Policy Statement for Highly Productive Land, the LUC class land is considered highly productive land. I'll just note that the balance of the site is LUC class, predominantly class 4 with a little bit of 7, and so that would be outside their highly productive land. A limitation of the NZLRI map information is that it was compiled back in the 1970s, and it did use the soil surveys that were available at the time, and it was such, it wasn't obviously kind of derived for assessing highly productive land because that wasn't in play then. But the main point is that the land and the assessments done at the time may no longer be represented by the land use or the land in its current state. So I undertook a more detailed mapping using the LUC classification system, i.e. the criteria within the system that is referred to in the NPS. My detailed mapping method involved a desktop assessment using aerial photographic interpretation of Google Earth images of the subject site dating from 2007 to 2023. And my assessment indicated that the subject site had been in an active quarry since at least 2007, and that the NZLRI mapped LUC class land has been and continues to be extensively modified by gravel extraction with no soil remaining. I also note in figure 4 of my report on page 7 that the SMAP soil mapping identified that area as, or coded it as unclassified, presumably because there was no soil present. I've just made sure I get the, my assessment indicated that the subject site had been in active quarry since 2007. I've said that, haven't I? And so basically I concluded that the NZLRI mapped LUC 3S4 class 3 land is now modified with no soil present, is most appropriately classed as non-productive land, or some terms can be called just quarry, and is no longer highly productive land based on the NPS definition of highly productive land. And I'm happy for any questions and clarification.
Thank you. I'll see if we have any questions.
I have one question. It's possibly a very straightforward question, but I just wanted to run my thinking past you. So the NPS HPL is concerned with not only the current state, but also the future potential of land. And so given there is no soil present and the land has been modified to the extent evident, does that also suggest that there's no future potential for the land?
This is purely my opinion, or my interpretation is that I wonder whether the NPS HPL considers the potential use of it based on the current land use as opposed to the current state of the soil. It's not very clear in the guidance and the reading. Otherwise, if you were to say that potential use, you could say that a road could be dug up and soil be reinstated and it would have potential use to be highly productive land, which would negate the value or the need to have an LUC classification. Yeah, that would be the way I'd see it. For the question came up earlier around quarries and restoration of quarries. Generally, my kind of limited experience is that there'll be what's called soil put on top, a soil cap put on the quarried surface for around 500 mils usually, but there's no usually no specific requirement to separate and provide a fully restored soil profile, I'd call it. So for me, a soil profile would include a well-defined topsoil, because that's really the essential part of a soil. A living part of a soil is to have a topsoil, and that's what would allow it to be returned to highly productive land. Yeah.
No, that's helpful. Thank you.
Okay, thanks.
From the 11.6 hectares of the LUC class 3 area, what percentage of that area would you estimate has had that soil removed?
Well, based on the air photos going back to, I think I've had 4 that I highlighted in my report, I would say just about, well, pretty much the entire area has had the soil removed. If there are any kind of remnants, they're very small, and I wouldn't be able to map them out at 1 to 10,000 scale, or even 1 to 5, or even finer, I don't think. You know, it is based on my interpretation, but I have been doing, we do this interpretation as part of the mapping as well. Usually it's a combination of observations on the ground or and air photo interpretation. The key point is that it's very, as you can see, it's very kind of white or pale looking, which indicates that it's gravel exposed and just in the entire area. It must have been relatively key because for SMAP to include it as an unclassified area, they really do that. It's the first instance I'd actually seen it, and so they would. And going back to the, I think in the Otago information, there's also quarry noted for that site, so it's not considered soil by both those soil maps.
Well, thank you very much, Mr. Hill. I had some questions, but they've been clarified in your answers, and also with our discussions with this page earlier about how the soils fits into the structure of the NPS HPL. So I have no further questions. So thank you for that. Thank you for your evidence.
Hey,
okay.
Thank you very much. Great.
Very good. All right. What I think we might do, Mr. Page, is have an early lunch, which will give the panel a little bit more time to get up to the site. And just for the record, I've arranged with Mr. Cross. I think, is that your name, sir? Ross. Professor Ross. I scribbled it down. We've arranged to meet up at the site at 1 o'clock with Ross to put us into vehicles and do the right things and have a drive around the site. So we'll come back by 2 o'clock to take Mr. Vivian, if that's okay. All right, and also just for the record, we won't be discussing with any officers the merits. We'll just be looking at getting factual position on where things lie and so forth. So we don't need to be accompanied by anyone else. Right.
Thank you.
Thank you. All right. Thank you very much. Yeah. Okay. All right. We'll resume the hearing, folks. I think we're ready to go. Thank you for that break. We've just been up to the site and we're shown around, and we feel like we know it a little bit better now. That's for sure. So we're grateful for that assistance the proponent gave us there. So there's no particular questions to come from that. So we'll just proceed with the evidence for now. So.
All right. I had asked Mr. Beck to join us this afternoon just in case the regulations are on the site visit. So if you're happy for him to be released.
Yes. Yeah. No. Thank you. We welcomed the evidence we got today, and having been on the site, it all seems to make sense. So we have no particular questions at this stage. So thank you, Mr. Baxter. Appreciate that. Yep. All right.
Right, in which case, I think in the hands of Kerry Vivian to present the remaining evidence. Now, you should have from him his original evidence and the rebuttal brief that was filed on Friday.
Yes, that's right. Yes.
All right.
Very good. Thank you.
Did you get a chance to read through my rebuttal evidence?
Yes. Thank you.
So attached to my primary brief, some amendments to the 7, 8, 9 of operative. Yes. In my rebuttal evidence makes some further suggestions. And now a statement which I think council may have. This wife has a copy.
Right.
I haven't actually signed it yet. So.
Oh, I see. Yeah, there's some signatures missing. That's
they give the copies to you.
The joint witness statement?
Yeah.
Yes, I do have copies for you guys.
Thank you.
Is that different from the one we've already got, or? I think so. They sent the new one, so I think we'll go with the new one. So this is no longer relevant.
Yeah, I'm not.
Changes there. So. Thank you. Oh yeah, this one's dated.
Right, would you like Mr. Vivian to actually sign it?
That's the only one missing. Well, we'll get one. We'll get you can just take that across if Mr. Vivian to sign it. We've got at least one copy with the original signature.
So the joint witness statement, I guess, is the piece of puzzle in terms of the zone.
Yes.
And what I was going to
suppose I do likewise need one set of zoning provisions, takes into account the primary evidence, the rebuttal and the witness statement.
We've got, so what I was wondering, if we've got questions of your evidence in chief, and then there's the rebuttal, and as you say, there's the JWS. So I'm wondering if we deal with them in sequence, and starting with the evidence in chief, and then we can adapt as we go. You know, there'll be some things that you'll say that's been dealt with in the rebuttal, but it's hard for us to process all of these things in one time. So is that the best way to do it, do you think? Or?
I think it is.
Yeah.
But before I forget, and everybody else forgets, you're now the holder of the only signed copy.
Yes.
And I asked Karen to scan and circulate that electronically at some point. It doesn't need to be now or even today. But just so that we've all got a record of what's actually been signed.
Absolutely.
So that's that one.
Where would you like it circulated to? Just so I can do it once we've finished.
Well, if you could send it to both Kerry and I. But of course, it will need to be posted on the council's website because the evidence is coming.
No problem at all.
All right, no, that's fine. So there's three elements to your presentation. There's the evidence in chief, there's the rebuttal, and that's relatively brief. And then there's and I'm not sure if you had a summary statement, but that's fine. We can deal with the evidence in chief.
I don't have a summary.
That's fine. That's fine. No, preoccupied. Yes. All right. No, look, that's fine. So we've got your statement of evidence in chief. Which I'll just do. And did you want to present anything there, or would you like us to go straight to questions?
Probably don't need me to present.
Okay. Okay, that's fine. We'll do that. All right, we'll just get. There we go. Right. So what we might do then is we might just work through it, and as the panel have questions on any particular page, we'll just chip in. But what we would like to do towards the end of it maybe is to go through the provisions, and I've got some questions on the mechanics of those, if you like, and you can help us with that. So we'll go to the sort of the bigger issues, I guess, at the start, in front of it. Right. Okay. No questions on page 1. Backgrounds. Anyone got any questions on the background section? That's paragraphs background to plan change 19. We've covered some of your material already in questions and legal submissions, so we'll just try and be.
I've got one question there. At paragraph 21, you suggest that the applicant might submit a holding appeal. Given what we've heard from Mr. Page this morning, could you just talk through whether that still applies or how that might fit into the ideal scenario?
It may have to occur if they're in a situation of PC19 being decided. No, sorry, PC21 being decided before PC19.
Yeah.
Right.
Yeah. But I guess the point of the paragraph was is there option for full voting necessary?
Right. So that's more for your own benefit. That is not something we should necessarily be concerned about, is it? Okay. All right.
No, it's just a way of using that process for the vehicle to align the two decisions we need to.
Yeah.
Okay. Thank you. I had the same question. So. 22. So in paragraph 22, there's mention of the PC19. There's mention of the 543 residential allotments. Was that part of the Fulton Hogan submission on PC19 as well? Did that come up there as well? Do you know? Was it?
No, but what just trying to remember quite some time ago. The PC19 submission saw no and medium into residential over the site. We went, by the time the hearing came on PC 19, PC 21 had been lodged.
Yeah.
A maximum of 543.
Oh, I see.
And then, we didn't, at the PC 19 hearing, because PC 21 had been lodged, I attended the hearing and gave evidence, but we didn't go into provisions or anything like that. We're mainly concerned with the future-proof overlay concept and making sure that would fit the full paper site if that was adopted.
Okay. All right.
In paragraph 22, I guess what I'm saying was the 543 maximum that we're promoting under PC 19, PC 21 should relate to PC 19 as well. So those provisions get transferred across.
I see.
So it's the same geographic area and the same people obviously.
Okay. Okay. All right. Next one I've got is 34. So the one before that.
36.
Okay, see I certainly. Oh yeah, 34. All right, yeah, just paragraph 34, there's the effects on centres. Do you note that there's an inconsistency in the GFA figures? And Ms. White correctly identifies that the economic assessment states that the proposed plan change includes a small commercial area expected to span about 1,800 square metres of GFA. However, that plan provisions allow for up to 800 plus 1,400, which is 22. So you say in paragraph 34, despite this inconsistency, Ms. White basically confirms Mr. Colgrave's assessment. But I was just wondering, is there still an inconsistency that we have to address here somewhere?
No, well, yeah, there is an inconsistency between Mr. Colgrave's report and what has been notified in terms of the zone commitment, but it is very minor.
Very minor.
Like that. In terms of the size of the problem, seemingly.
Right. Okay. And the provisions themselves, do they cap it at 2,000? Is that what I understand? Yeah. We'll come through those at some stage.
It's on page 818.
Oh yeah.
Attachment 2. So 800 meters floor space for convenience grocery store.
Yeah.
1,400.
Right.
For cafes, restaurants, and bar.
To 2.2's the cap.
2.2.
Okay. All right. No, that's fine. Thank you. All right. I've got nothing till 48, so you can ask 36.
I'm sorry, I did that.
I did. Okay.
So at paragraph 36, you discuss Mrs. White's observation that the possible water feature, in terms of being in general accordance with that, but you disagree with her that the site could be developed in line with the underlying residential zoning, should the water feature not eventuate for any reason. And in your rationale for that, you've noted that anything other than a water feature or open space would be a non-complying activity, pursuant to the proposed rule. My question is, if there is a pathway for someone to apply for that, does that not speak to Mrs. White's point about there being that it could be developed in line with that underlying residential zoning?
For a non-compliant activity, I would agree. But I don't think it would be quite difficult given the structure and theory is basically with the space law for the waterway there. But I agree there is a pathway.
There is a pathway, whether or not.
Can say there's a pathway given there's also a cap on 543, but 543 is an activity back.
Yeah.
So, there's a pathway to go another 543 as well. So, I think it would be quite difficult to do anything
Other than,
what's in the structure plan.
okay, thank you. And in a similar vein, in paragraph 39, you mentioned you've put some thought as to whether the water feature would be better zoned something other than residential.
Yes.
And you used a comparison at Plaza Moorings with that didn't benefit from the added protection of the structure plan. I was interested in what zones you did consider and why you ruled them out.
Well, I was thinking rural, which would be the most obvious one, but given, I guess I got to the point where on this stage of my evidence, I was thinking structure plan, and that gives more certainty than what Plaza Moorings have in terms of being zoned residential. So it's probably more, it's stronger to have a non-complying regime under a structure plan zoned residential than rural.
Okay. Thank you.
Ian, if you have any questions as we go, just chip in. I think I'm up to paragraph 48. 48. Yeah, paragraph 48 is a similar line of questioning, I guess. The wetland, there's an opportunity. You know, there's an opportunity for ecological restoration, but it's not guaranteed. I'd imagine what will happen is if this goes through, there'd be a subdivision application, and you would expect that that would be addressed as part of the development, and officers would refer back to this documentation and see a master plan and a structure plan, more importantly, and that would, you'd imagine that they would be basing their recommendations on that. And so is that how it would work in practice? That would have some sort of status?
It does work like that in practice.
Right.
The difficulty though is the engineering code of standards, which usually don't like what
they go for hard engineering.
So,
right.
So the Central Otago district in particular are very open to that sort of alternative ecological restoration.
Okay.
So but it will be dealt with through the data. So
all right. And is there any assessment criteria that would trigger that sort of spur the people to reflect back on these plans? Would that come up in the assessment matters?
Yes. Well, I'm proposing a subdivision assessment matter on page 718, which requires a general compliance with the structure plan.
Yeah,
so,
that's right.
So at the time of the restricted discretionary subdivision, the processing plan engineer.
So that provides a link.
To the fact that you have to provide the structure plan, which includes those.
Right, no, that's fine. And actually, just while I'm on that, just to be absolutely clear, and I think I'm clear, there's a master plan which Mr. Bax has taken us through, and as the evolution of this plan change, we've now got a structure plan which is more definite, if you like, and has some status in terms of the assessment matters which you've referred to. So is that how it works? The master plan is really just a conceptual thing for us to note, but the structure plan has some status.
Yeah, there's a future development plan which is ultimately what they want to do on the side, and that's the plans that we presented to the community meetings.
Yeah.
Then there's the zone plan, which is your rural resource area, business resource area 2, and industrial resource area 2. Yeah. And that's what will go into the district plan. Don't really update the maps anymore, I don't think. Right. But that's on the GIS maps. And that will have the overlay, the scheduled activity 25A overlay over top of those zones. Yeah. And then the structure plan is attached to chapter 7 of the ODP, or not sure what chapter number it is of PC 19, after the load or the empties.
And I think the panel members discussed this briefly, but is there Mr. Page might be able to answer too, is there a package of these are the pages we want you to insert into the district plan? We've got the residential, industrial, commercial provisions, but we're just not entirely clear about the maps to go in, and you've just told us, but I haven't managed to write that down properly yet. Is there a package you can give us?
Yeah, because the maps
yeah.
Going on the council GIS system, we can't really reproduce those.
No. Okay.
We have given the Mr. Baggs knows the team, but I think he has given the data to the council for the zoning maps, but we just haven't seen those from the council yet.
Okay, we'll come back to that.
But
okay.
Normally what happens is if the commissioners, the panel approves a plan change, then the council's BIS department comes up to us and says this is the information that we need to produce the maps for parts of the plan.
I see, yeah. Okay.
But yeah, we're happy to put that package together overnight.
Yeah, or it could be done as part of the reply, but it's just so that I guess what we're after is to be crystal clear on what it is, how you'd like the plan changed, that this is how you'd like it changed, rather than us commissioning maps to be drawn up and things like that if we were to go down that track. But I seem to recall that one of the plans hasn't been updated with, is it the landscaping along the frontage, or there's something that needs to be added to one of the plans? I'm not sure if that's been done. Is it landscaping?
Yeah, there was. Had my rebuttal evidence.
Yeah.
My primary evidence. It's white wanted the state highway setback added to the
That's the one. Yes.
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 So that has been updated.
That has been updated. Okay.
Attached to chapter 7.
Okay. No, thanks for that. We'll come back to all of these things at the very end. Sorry to interrupt. It's sort of related to my question, but look, you've got a question now? Yeah, sure.
With the stormwater filtration features such as the wetlands, and what long-term maintenance will be required and who will be responsible for this?
Yeah, well, from my experience of quite large subdivisions like this, usually the landowner will have responsibility for either a 5 or 10 year period, or is reserved given to the council. It's reserved. That's what happens in Queenstown, at least. I'm not too sure about the city, Otago.
Would that be
usually there's a maintenance period that the developer has to stand by. There's also often these areas now retained, that they're not vested as reserved, they're retained as either body corporate or shared ownership as well. So there's a few different options there.
Would that normally be sorted out at the subdivision stage?
Yes.
Yeah. And the council, if they wanted it dealt a certain way, would ask for that and negotiate that. Okay. All right.
Yes. And usually I see that even that they will want this.
All right. I've got a question for 55.
Are we talking about questions that are likely to have a rebuttal?
Well, I was just trying to go through evidence in chief first, but yeah, happy to jump in here if you want to. Yeah.
Right. First.
Yeah. Do you want to go? Oh, okay. Right. Sorry, we're just getting organised here. Yeah. In terms of the paragraph 55, it is, and the preceding paragraph about the connection to Pony Court. I just wanted to understand where that came from. Was that if I understand it correctly, and I might be wrong, the connection wasn't shown in the original structure planning or master planning. One of the submitters, PV Development, they requested that they own the land, and they wanted the connection actually formally shown on the plan. So that's where that came from. Is that right?
No, it was,
No.
the connection was always shown on the future master plan.
Oh, was it? Yeah. Okay. Okay.
And yeah, and from what I understand, an agreement is in principle has
I see.
been reached in terms of getting that connection through.
Oh, that answers what the question I was going to put to you. Actually, I was curious as to whether that had evolved through the process, and I mean, one of the implications would be that there'll be more traffic going down the internal roading network of the, Pony Court and so forth, but that was shown in the original documentation as notified. So, yeah, okay. All right.
I think the differences, I think it was shown as a possible connection in the original documentation.
Right.
But PVDL submission is that it should be an actual requirement to do it.
It should be firmed up. It should be, yeah.
Of course, Northern Home wasn't in a position to make a requirement until agreement has been reached to allow it to happen.
Yes.
Otherwise, it could be held to ransom by PVDL.
Because it's, yes.
But I think that problem was likely to resolve itself formally during the course of the spec.
Okay. No, that's understood. Thank you for that. Okay, we'll just keep working through your evidence, and any questions on rabbit proofing?
Yes.
Okay. Rabbit proofing.
Rabbit proofing. Yeah. So you have promoted some different wording for the matter of discretion in relation to pest management. Sorry, I've just lost my train of thought here. Paragraph 58, yeah. Yes, so and in doing so, by removing the reference to Pliza moorings, you also removed specific reference to rabbit control. So you've kept it as a more generic term in that matter of discretion. Could you talk us through your thinking there?
Well, my thinking is simply that pest control is wider than just rabbits. And yeah, I know rabbits are a big problem in central Otago. I spend a lot of time trying to rid them of my property as well. But there are groups in Queenstown now that are doing trapping of rats, stoats, all sorts of animals, all sorts of pests, and yeah, I just didn't see why it had to be limited to just rabbits.
Sure. And from memory, the submitter considered that a rabbit stop might also be required. Did you consider that specifically?
Not specifically, no. To be honest, I didn't know what that would look like on the road.
Yeah.
Horrible.
And that aligns with Ms. White's view as well. Yeah.
And there's also probably other linkages that would need to be stopped as well, like some cycle trail for the farm objects.
Yeah. Okay. Thank you.
Okay. Okay. That's good. Well, I was just interested in the education thing, the provision of a school, as requested by MOE. I think that issue might have resolved itself. I think we've got a tabled statement from MOE, but yeah, my original question was paragraph 64. You've said, I agree with Ms. White that including provisions to accommodate future educational facilities would be unusual within an ODP structure plan. That would be subject to underlying zone provisions or designation pathway. I think originally they just wanted provision for this is where a school would go, and then they would be responsible for they'd be responsible for the outline plan or designation, wouldn't they?
Yeah. I've sort of dealt with this bit further in my rebuttal.
Yes, okay. Oh, you have to. You have to. Yeah. Sorry.
It's my understanding that in terms of education facilities, the plan across the zones is quite enabling.
Yeah.
So,
Enabling.
really don't see any, if the goal does go on there in the future, something, I don't think it's going to be a problem at all.
They just have to secure a slot.
And given also that
All right. Okay, no, you're right. You have dealt with that in the rebuttal. That's need to catch up with these things. That's fine. I'm up to, so any questions?
I just got one question at
Yeah.
62.
62, yeah. Okay, cool.
At paragraph 62, you are commenting on the concept of the future growth overlay in response to Ms. White's recommendation, and that you have contemplated it, but that it doesn't sit easily within the mixture of urban zoning as sought. Could you just explain that from, I understand that in the PC19 context, you were submitting on that very concept, but now your preference is for the rural approach as opposed to the...
the difficulty we have PC 21 is we are seeking residential business in industrial zoning. The future growth concept PC 21 only relates to the residential zones.
To the PC19?
Or PC 19, sorry.
I see, yeah.
Only relates to the rural, the residential zones. So then we're going to have a situation where the business and industrial aren't subject to future growth overlay, but the residential component is.
Yes, I see, yeah.
I guess the answer to that could be to insert into the business and the industrial zone a similar future growth overlay. What comes out of PC 19, but we just don't know what that is.
Yeah, sure. Yeah, thank you.
Right, okay. I haven't got a lot of other questions, but I was just going to ask you one about the location of growth. I think it's paragraph 72. Just go through to that. Probably one of the sort of more higher level sort of aspects is the location of growth. I was just going to ask, you've obviously been involved in consultation with various parties, and we didn't get a submission from ORC, as I recall. So are you aware whether basically they considered this? And well, for instance, they have opposed other plan change requests that were closer to Cromwell than this, and I was just curious as to whether you had any inside knowledge.
Yeah, we early on in the process, we met with the regional council. And at the time, they had a urban designer employed, and he really liked the concept, and he left. Then PC 21 was notified and there was no submission, so
right, okay.
I'm not sure what happened, but we did consult.
You did consult, no. All right, no, that's okay. We can. We're not involved in supposition, but the facts are they haven't submitted. So, and you've had some.
I think that detail in the consultations section.
In the AU. Okay.
Index A to the.
There's a statement in there. Okay. All right. Thanks for that. That's fine. Any other questions around that area? Okay. I was just going to ask you on paragraph 75, is there some typographical things there? Those words appear struck out, but I think the underline's in the wrong place.
Yes, I've got that.
Oh, okay. That's right.
Shouldn't be struck out.
Okay. Okay, that's fine. I haven't got anything else until I was going to ask you some questions at paragraph 90 on the NPS and the scheduling and that, but I think Mr. Page has dealt with that earlier in submissions, and you've got extensive evidence on that as well. So thank you for taking us. Thank you for providing that analysis. We did go and look at that part of the site today, and we can readily understand the evidence before us on that. Thank you. Yeah, I've got no further questions of the evidence in chief, but the,
One on NPSUD.
yeah.
In your statutory analysis in relation to the NPSUD,
Yes.
had a question around, given the proposed standards that limits development capacity to a certain yield, does that bring into question the significance of the development in terms of the numerical significance of what that is? That a factor that we need to concern ourselves with? So if the NPSUD is live and applied, and the council has to be responsive to unanticipated plan change, and that those plan changes has to have significant development capacity. And if the yield is being capped, does that bring a question into play for us?
I'll still say 543 residential development could be significant. And
yeah.
In
terms of the medium and long term, like the different phases of that development?
In combination, maintenance from intensification.
So that's the questions on the evidence in chief. And what I was planning to do now is to go to the provisions that were in the document as notified, which are business resource area and industrial resource area. And then we didn't have residential, did we? No. And then go through your rebuttal evidence and then come to the residential, because that's the way it sort of evolved, if that's okay. And I had some questions about the provisions themselves. So if you've got those somewhere nearby, get you to take us through how some of it works.
Yeah, I think the
hold on, let's residential one. Oh,
you want to do the business?
yeah, sorry, I've got myself out of order. Yeah, the business first. Yeah, okay. Just go through. So the changes are all shown in red font, aren't they? So, so the first one I have, some of these are possibly grammatical or typos, and I'm only asking just so that you can tell me if I've got it wrong. But page 8.4. So this is the business area. 8.2.9 limited. So to provide for development of high quality convenience retail activities limited in scale. So it's got is there limited scale.
Yes.
So that's just a typo. It should be in. Is that right?
It might be
or two.
Easier if we look at the attachment to my primary evidence.
Oh.
That corrects.
That corrects it.
Yeah.
Sorry. Yeah. Okay. So you've picked up on some of these things.
Yes.
Okay. All right. Now look. Unfortunately, I haven't got that sitting at my fingertips, but I'll take your word for it. And
what you will find in the version attached to the evidence, the corrections are in green.
Okay. Oh, look, in that case, I'll trust. I won't ask any questions about green.
What was notified?
Yeah.
Green is
yes.
They report.
It's picked up on those things. Yeah.
And I've added a little bit of blue as well through my primary.
Right. Okay. Okay. That's all right. I was going to ask you 8.4. Yeah. While we're on that particular provision, this is not a grammatical thing. It's more. It's a question I think I can ask that you may not have considered. to provide for development of high quality convenience retail activities. I was just going to ask what is meant by high quality, and I can understand the English meaning of it, but in an RMA sense, high quality. Why would we have that as a policy? That just I should reflect on that.
Yeah.
Is it high end? Is it sort of good amenity, or is it?
If you look at the policy previous or inventory, like they talk about high quality accommodation.
Okay.
And so that came through.
Those two.
Can change 13.
Okay. So you've been consistent with that.
So I was.
Okay. No, that's a fair answer. I hadn't looked at that. All right. That one. Yep, that answers the next question too. That one. Page 18.
Keep the bay one through talks about maintain and enhance the environmental quality.
Right.
Quality came through.
That brings in an environmental aspect to it. Okay. All right. Thank you for that. I haven't got any more questions on that chapter. I think what I'll do is suspend my questioning on the provisions until I've had a good read of the track changes that have come through in the appendix, and I'll do that open night. So I won't trouble you with those right now.
Yeah, if I can go away and just update those.
Yeah.
After this, you'll have the most up-to-date ones.
Yeah. That's right. And just on something you said earlier, you added provision, an assessment matter, restricted discretionary activities, number 18, within the Parkburn area, general compliance with the Parkburn structure plan. So that was an answer to a previous question. It links back to the structure plan. So
that's the residential track.
That's a residential, yeah, that's right. So sorry, I've skipped through to there. So as an assessment matter, general compliance with so that's limiting council's discretion to assess whether that plan has been complied with, isn't it? Is that the right way to frame it?
Correct.
It is. Yeah.
And there is also backing that up a non-compliant rule.
Like around, yeah.
Yeah, so if you're not consistent, on page 17, you see that number 9, page 17,
Oh yeah.
you're not consistent with the structure from underneath.
Yeah, that's right. And as I say, I'll question you more on that, because that page 727, Parkburn area, the Roman numeral IX, has got some errors in there, and I suspect they've been fixed up, have they? Is it? In terms of the references.
Actually, sorry, that reference number 9 is incorrect. That's actually
It should be
number 13.
Yeah, okay. All right.
Page 739.
Yep.
All activities and development must be carried out in general accordance with Parkburn structure plan.
Yep. No, that's right. I went through this document and I saw some errors in terms of the transposition, but they've been fixed. So I've got no more questions on that for now. So I'll work through it all again tonight and make sure it's all right. Thank you. Okay. Look, I don't think I have any questions more of the evidence chief. We could probably move through to the rebuttal evidence now. Okay. And it's relatively brief evidence, isn't it? I'm wondering whether you might just run through that. Yeah, for us to just get some context. Yeah.
So, start with the So in terms of the structure plan, they wanted to expand the residential business activities over that area of the class 3 soils.
Yeah. Yes.
And in terms of my rebuttal, I can't see how under the submission that there's any jurisdiction for them to actually ask that their road, their submission talks about future treatment opportunities for roads and infrastructure. We've done the roads through the structure plan by showing through 2 connections to the boundary and one partial to the boundary. Infrastructure, I don't know how we can future-proof that. But yeah, and in terms of the zoning, I think it's beyond jurisdiction to change it from the submission from industrial.
Okay. Questions? Just before we move on. So even aside from the jurisdictional thing, what I understand they're asking is to rezone to a land use that's more favourable to future development of their land, which hasn't been progressed, or we've got no plans in front of us, or haven't been lodged. And would it be good planning to provide the antithesis of reverse sensitivity? Sort of, you basically they're asking for a sensitive land use to be put on the boundary with a current quarry operation. So, from a planning point of view, would you have any comment on that as well?
Yeah, it sort of goes against everything that we're trying to do in the plan change between, in terms of having the industrial between the more urban development to have the buffer. So I certainly would support doing that. As well as said this morning, that the dust going into the parkroom site from the north, without their suppression, that suppression could be 10 times worse for the, how many times was it? Probably 1,000 times worse for the even more people.
We saw that dust suppression mechanism today. Yeah, it's interesting. Yeah, so. Okay.
And in relation to the submitters' comments around that, you mentioned there were 2 connections in the north, and then there's the one that's partially connected, and they've queried why it terminates before reaching the boundary. Do you have a response to that?
I only thought there is that particular road heads across the Cuthbertson Street. And so at some point that bridge may have to be upgraded to something that if it was urban, may have to be upgraded way larger than it is now. And I just don't know why you would have to do that to join property which is zoned rural, has several accesses already, including legal access. The first road as you go on, there's in fact legal access to the road. So,
It's add something to that. Parkroom Street, there's like a marginal strip running probably the state highway down to that. Well, we're currently in the process of negotiating to shift the stream into its actually lies on the ground. So it's currently marginal strip does not follow the stream. And part of that, the northeastern corner of our sites theoretically landlocked at this point. We are hoping to secure an easement and perpetuity across marginal strip when we should marginal strip to where it should lie on the end of the stream. The stream is less than 3 meters width, but because we would want to secure a legal secure access residents across the street that tidies up loose ends.
Okay.
So that's a small part of that ongoing process of securing other approvals and authorization required to operate whatever form we find we have.
Thank you.
Thanks.
Thanks for that. All right, I think that's all the questions we had on that particular aspect. And PVDL, tell us about that.
So this is that small area of between the existing diesel quarries.
Oh, yes.
Residential or paving down.
Right.
But that's why there's jurisdiction from zone it further, and I guess we're quite on the back.
Okay. We'll ask to submit some more questions about that, but that's clear from your point of view. So thank you for that.
I'm a little unsure from Mr. Carr's evidence whether they want that strip of land included within the structure plan, or whether it's just residential zoning which sits outside the structure plan.
Yeah, because that would have an impact on the triggering and so forth.
Exactly.
Yeah. Okay. Fine. No, we won't ask any more questions about that, but we'll certainly ask them some questions. Thank you for that. Right.
Otago, first point in relation to a cultural impact assessment. But I know that Paul Hogan committed an assessment years ago, or sort of received one.
Okay.
I don't quite know how that would work. A rule of a plan saying request or commissioning a CIA prior to the structure plan.
No, it's
I'm not quite sure what they're asking for here.
no, it would seem that if there was one, we'd need to see it now. But in terms of decisions on rezoning, but
number two. I think this would naturally occur anyway through the 223, 224 process. It doesn't make sense to do that work prior to doing the residential subdivision adjacent to it.
okay.
Number three.
Yep.
I've had a look at the yard, rear yard, or side yard setbacks, and I agree that on the northern boundary of the industrial area, there should be a setback which would sort of allow, it is sort of a buffer there at the moment in terms of planting, so just sort of protect that. So I've recommended there the addition of a 10-metre setback within the rural zone.
Yep.
For the industrial buildings.
Right.
Number four, we wanted cadastral survey markers added to the structure plan, that are actually there at present.
Okay.
If you look closely.
Okay.
Number five, I refer to page on that one.
Yep. Yep.
The six. Yeah, I agree there that paragraph 24, that those words could be improved by reference to a communal supply.
Right. Yes. Okay. Yeah. You probably don't need to go through the next section. I think we can see that you've suggested a change for the fire and emergency to provide adequate servicing for fighting. And so that's a matter that can be considered. And so the relative standards can kick in at the appropriate time. That's understood.
On 34, I recommend another
standard.
sub-clause, which I really don't think in an urban environment, you're going to get a house with more than 50 metres along the road, but anyway, that is something that consider.
Okay. And we've probably been through the next one. You probably don't need to address this on the Ministry of Education letter, so that's fine. Right. Okay, that's good. All right. Look, I think we're at the point where we can look at the JWS in a bit more detail, and you can help us with that. I've still got the only signed copy, I think, so I'll try not to dog you that one too much, but just tell us about it. Yeah.
Oh, that will.
Yeah.
Yeah. Actually, sorry, give me one more if you've got it. I won't mark that one. All right, thank you.
Yeah.
Yes, so this I'm sure it's available Friday evening.
Yeah.
So it's Mr. Smith and I, with Otago, Prince Kelly Watson, Kate Kelly, who are all ZTA planners, ranging from Auckland to Dunedin.
They put 3 people on.
Yeah.
Right, okay. Very good.
Safety engineer, I think he's.
Oh, I know this. Okay.
So there was pretty much agreement with the plan change in terms of the standard, the rule above 271 allotments.
Yeah.
But what NZTA were concerned about was a rule in there about less than 271. So ensuring that the roundabout and the existing access is upgraded for any development. I was of the opinion that would occur anyway through 2 mechanisms. Firstly, through REA subdivision. Secondly, ZTA and particularly the landowner and they won't allow anything to happen without their permission anyway. So you first go to page 4, paragraph 5.3.
Yeah.
So J was inserted as a new rule to deal with less than 271 residential allotments. And then J is the old J, which cut from the difference, the name remained unchanged.
Oh, I see. Right. Okay, so I think Mr. Smith might have taken us through some of that. So there's a lesser standard up to 271, then a higher standard after that. Okay, and that's been agreed. It's part of the statement. Yeah. Okay.
And then at 5.4, that is my restricted discretionary activity, actual discretion. And then C has been amended. ZTA were wanted the ability to require the Pony Court connection early on in the stages of development.
Right.
And they also wanted to ensure that pedestrian or cycling access through to the Dunstan Trail.
Yeah.
A Dunstan Trail.
Yeah.
Was enabled at each stage of development. So, so we agreed to put that in as an assessment.
So 5.4 was that was that not, wasn't any discretionary assessment matter? That's entirely new, is it? That five,
no.
oh, just that bit there, within the park venue.
Yeah.
Oh, that's it there.
It's was printed out and
Hasn't come out on my one in any particular.
Yeah, I think in the original blue document, these are all kind of different.
Oh, okay. So it's that bit on C. It's 24. The reference to 24.
Changing C.
Yep,
It needs to stop at west north direction.
Oh, I see.
So.
Oh, okay. No, that makes sense. Maybe if this is going to be the signed copy, we have to get one that's showing the bold the colour on it, because it doesn't show that. It just shows it all the same font. Yeah. Okay. We'll sort that out later. Okay. Thank you. So that.
From my rebuttal evidence, which.
Oh yes. Yes, that's right. Okay.
In paragraph 6.2, we discussed whether a similar rule for less than 271 should be inserted for development in the industrial business zones. We decided that it's unlikely that the business zone will be developed without the residential. So, and usually they'll develop a lot of residential before they'll even consider business zone. But in terms of the industrial resource area, because it's an existing use to some extent, ETA wanted the inclusion of a rule there number 14, which upgraded the existing access prior to any more development.
Right, so that's that one there. No further industrial. So, okay.
And from what I understand, it's in approaching the site from Wanaka. It's the left-hand turn lane into the intersection.
So in terms of that's a rule. It says no further industrial activity. I presume that'll have to be linked to some sort of date, or you'll have to have some certainty around it. Like, do you think, in terms of rule drafting? Because it's not an assessment matter; it's a rule. Yeah. I just invite you to think about that as to how that's implemented. As White might be able to help with that later on. Have a think about that. It's not critical. It's just a matter of helping the planners at the council understand how they should go about implementing that.
Then in part 7, we acknowledge that there might be some minor confidential evidence required to have that.
Okay.
Not really something that
no. So just in terms of, this is the first time we've been through this, but I haven't looked at the background section, but is there anywhere that these deal with the provisions that have been agreed on? Is there anywhere in that statement where NZTO or Waka Kotahi is saying, on that basis, we withdraw our submission? Do you know? Is that, because at the moment we've got a submission from them, and now we've got a joint witness statement.
Yeah, I understand they
we had a meal. No, okay. Yeah.
One of the three things I can't, or which one was going to be available for pushing tomorrow.
Okay, we haven't got that communication, but we did get a memorandum from them. I don't know if I've got it in front of me. There it is. I think. Basically, so yeah, when they requested filing of late evidence, they said that our concerns are now narrowed to access and design matters. So I think putting that together with the JWS would indicate that they're not pursuing. Yeah, unless they tell us.
My understanding is 100% happy.
Right. Okay.
I do think I think it's in an email we Kelsey said she would be available.
Oh, I see. Okay.
If we wanted to sort of come, we had some questions for NZTA.
All right. Well, we've got it. That's right. Okay. Thank you. I've just been told they did make themselves available for questioning. We have got a slot tomorrow afternoon where we could ask them a question. So we, as a panel, we'll discuss whether we need to do that or not. But thank you for all that. Thank you for presenting this at short notice. And on the face of it, it looks like those matters have been resolved. So thank you very much for everyone who took part in that process. Excellent. Now, is there any other questions we've got of Mr. Vivian at this point? Ms. White, have you got any questions? Have you got any questions? No? Yeah, on board with all of that. Thank you. That's great. Okay. Yeah. Okay, thank you. That's all the questions we have for you at the moment. All right.
Well, that's us for the day then, until we get back with Mr. Colgrave first thing tomorrow.
That's right. That's right. And thanks for your. Well, I think we've kept to time pretty well. Actually, that's excellent. So we'll have a break for tea, and we have some submitters. Right. Okay. We'll resume the hearing, folks. Thank you for your patience. Mr. Taylor, would you like to come forward to the table there? Thanks, and we'll hear from you now. Thank you very much. Yep, thank you. Mr. Taylor, we've got your statement you've handed out today, so you're going to take us through that. You're welcome to do that.
Yes, I'll read it out.
Yes, read it out. Yeah, that's fine. Yeah.
Good afternoon. I'm Stu Taylor. I'm part of the FSB Team Morans, speaking in support of the rabbits are a pet, and many communities around Otago have problems. Landowners are required by law to control their numbers. Communities of urban and semi-urban properties with a multitude of owners can struggle to achieve any control. Team Morans was in this situation. We had a plague of rabbits destroying gardens and making reserves dangerous and unusual. In 2000, pest-free Team Morans was formed to tackle the problem. 3.5 years later, we consider the subdivision to be 99% rabbit-free. We are very pleased with that result and also very keen to sustain it into the future. It has come as a result of a cash spend in the order of 20 grand and a total of approximately 800 hours of volunteer work, poisoning, fencing and habitat control. We are fortunate the subdivision has depth of boundaries which were almost completely rabbit-fed. A major hurdle was the lakefront reserve at the north and south ends of Team Morans, where the cycle trail enters and exits the subdivision. Otago generously fabricated and installed rabbit spots on the cycle trail, and we completed the fencing and gates required to make those areas rabbit-free. We consider the rabbit stops to be very effective. Evidence for this is the high population on the outside and very little sign of rabbits on the inside. This gives us confidence that a rabbit stop on the road will be there. One of the keys to staying rabbit-free is maintaining our rabbit-free boundaries. Without it, we will face constant reinfestation. That is why we are requesting a rabbit stop on any road between Team Morans and the Otago development. The second part of the submission is a request for a rabbit-proof boundary and an ongoing rabbit control program in the new development. This is a plea on behalf of future residents of the development who can't be with us today. We feel it is time residents of a new subdivision can reasonably expect to be spared the damage a rabbit population can inflict on reserves. The ideal outcome for the future residents would be for Otago to have a comprehensive rabbit control program as part of the development process. This would make the opportunity to be part of a new community more attractive, make protection more saleable. while we wouldn't hazard a guess as to the figures involved, we think it's possible that expense of controlling rabbits could be recouped in increased section value. In conclusion, we have shown that it's possible to live without the scourge of rabbits, and we would like to see new communities have the same opportunity. Thank you for your time.
Thank you. Thanks for presenting that to us. Now, you've been here for a little while. You might have heard some discussion about your submission by the applicant. Did you hear them talk about rabbit proofing, or you're not here at that time? So,
I'm fairly dead.
Oh, sorry, I'll speak. Oh, okay. Yeah, so I think we understand the issue. It's a big issue here, obviously, isn't it? And so what the panel's considering here is the zoning, to zone this land or not to zone it, basically. And the way things normally work is if it's rezoned, things like rabbit proofing are one of the matters of detail that come up in the subdivisions considered. And what the discussion has been about is how provision should be made for that in the assessment matters. And there was a specific reference to in the officer's report, measures required to maintain and enhance rabbit control measures in Pisa moorings. So that would be a matter that the officers would have to consider when a subdivision is done. How are they going to address that? And the proponent or the applicant have suggested just some fine tuning of that word to deal with pest control in a wider sense, not just rabbits. So that's how they propose to deal with it. And rather than actually provide a definite fence in a particular location, it's determined at the time of the subdivision. So if you've got any comment on that, that's the general approach to how it would be handled. Does that meet your concern?
Well, pretty much part of the reason that we're bringing this up for discussion is we would like to see the developers take on board the concept of being rabbit free.
Yes. Yes. Rabbit free.
We understand this process around the rules that they impose on them, but to be really effective, we feel that the inputs need to come from within the development group.
Okay.
Within the developers.
All right. Okay. Understood. Yeah. Okay. Thanks for that.
How many in your group? How many people are you representing today?
We have a committee of 8.
Yeah.
We don't have a membership, but what we've done is ask residents for a one-off donation of $100 per household. And we've 80 households have contributed, so that
a lot of volunteer hours for if it was just the 8 people. Yeah.
Yeah, and I mean rabbits are a pest. You've just got to be consistent. We've had on our side, we know we'll be consistent.
Yeah. And are your concerns solely limited to rabbits, or do you see other problems with other pests at all, or are you very focused?
At the time we started rabbit control, we got the ferret traps.
Ferret.
We have a regular ferret trapping program, and we've caught 70 or approximately 70 ferrets today. We had a campaign, control program on common wasps last summer in the subdivision and got rid of wasps. If paper wasps, we don't take that bait. That was very successful.
Okay.
We other do other bits and pieces. We undertake a bit of tidying at the front entrance, habitat control, very piles of rubbish along the lakefront reserve and things like that. There are breeds nesting in the subdivision, and we're in part of finding them on nesting platforms. So we, we're sort of involved a bit more than rabbits there.
And from what I've understood from your submission and your presentation to us today, in your experience, the fencing and the rabbit stop kind of work in tandem together to assist rather than one or the other. Is that what you're saying? So the relief that you're seeking is that there's a rabbit stop in addition to fencing?
Well, the rabbit stop is like a council.
Yes.
On the rail trail.
Yes.
Cyclists pass back and forth Leslie.
Yes.
Rabbits like go over it.
Yeah.
And then fencing from there on either side of the rabbit stop. Yeah, so part of the rabbit boundary.
Yeah, I see.
Yeah.
Thank you.
Thanks for that. Right, thank you for that. We've probably got no further questions, Mr. Taylor. We understand what you've come to tell us about, so thank you very much for that.
Yeah.
Yep, appreciate it. You're welcome to stay and listen to the proceedings. There's one more submitter to come if you wish, but it's up to you. Thank you. And we have submitter Wally Sanford down now. Ms. Lyons has tried to contact him to see if he might come earlier, but apparently he's in a community board meeting. Is that right? And he's probably anticipating getting here at 3:30, so we haven't been able to bring him forward. Sorry, so we're just going to have to take a brief adjournment for the moment till Mr. Sanford arrives. Okay, take an adjournment.